Georgia Government Transparency and Campaign Finance Commission to order. Looks like we've got 4 items on the agenda that was posted for today's meeting. I don't see any need on here to amend the agenda as posted. Therefore, I'm going to go ahead and make a motion to adopt the agenda. Do I have a second?
Second.
We got a motion and a second. Do we have any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, so we've got the agenda set. Item 2 on the agenda, we've got one preliminary hearing today. This is case number 2019-0050 in the matter of New Georgia Project, Inc. and New Georgia Project Action Fund. Who's going to be presenting today on behalf of the commission?
I will.
Okay, so Mr. Cusack,
Yes.
and who will be presenting today on behalf of the project and the fund?
I will. Good morning. Aria Branch.
Okay. Nice to see you again, Ms. Branch. Will you be the only one presenting?
I will.
Okay. All right. What I have done is I have laid out a roadmap of what I understand to be the various allegations that have been made in the case. What I want to do is to run through the allegations to make sure that I've got a clear understanding for the commissioners today what the allegations are. Then I'm going to move in. I understand that there is a pending motion to dismiss the amended complaint. I'm going to go through that. And then there's also a pending motion to keep confidential the various, I guess, contributors to the fund. And we'll address that as well. So again, I want everyone to bear with me. I'm going to go through this roadmap, and I want anyone to speak up. I'm going to ask after I get through each of these issues, I'm going to ask if this is a clear understanding of what the issues are, because I want the commissioners to understand exactly what we're doing today. So this is the way that I've outlined this. Primary allegation number 1 is that, and I'm calling it the project and the fund. Does everyone understand who I'm referring to here? So the project and the fund failed to register and report as independent committees. Does the commission staff agree that that is the primary allegation number 1, the summary?
Yes.
All right. Now I'm going to go into the more specific allegations. The project and the fund did not register with the commission as independent committees in 2017 and 2018 in violation of OCGA 21534F1. Does the commission staff agree with that statement of allegation?
Yes.
And without making any admission on the issue of whether they were independent committees under the Campaign Finance Act, does the project and the fund at least agree that they did not register with the commission as independent committees in 2017 and 2018?
Yes.
Okay. The next more specific allegation is that the project and the fund did not file disclosure reports with the commission that were required of them as independent committees 9 times in 2018 in violation of OCGA 21534 A1 and F1. And I'm going to go through each of these 9 times. 2 months prior to the 5/22/18 election, 1 month prior to the 5/22/18 election, 2 weeks prior to the 5/22/18 election, the 6/30/18 supplemental disclosure report, 2 months prior to the November 6, 2018 election, 1 month prior to the 11/6/18 election, 2 weeks prior to the 11/6/18 election, 2 weeks prior to the 12/4/18 election, and the 12/31/18 supplemental disclosure report. Does the commission staff agree with that statement of allegation?
I think there might have been a June 30th supplemental report. Okay.
Yeah, I mentioned it.
Okay. Then yes, I agree.
Okay. And again, without making any admission on the issue of whether they were independent committees under the Campaign Finance Act, does the project and the fund at least agree that they did not file these disclosure reports with the commission in 2018, including the 9 reports specifically identified?
Correct. We agree that we did not file them. Obviously, we have arguments.
No, and again, I understand. I'm just trying to narrow down what the issues are. That's all. All right. The next allegation I have is that the project and the fund failed to disclose approximately $4,216,783.07 in contributions in 2017 and 2018 in violation of OCGA 21534 F2A. Does the commission staff agree with that statement of allegation?
Yes.
Without making any admission on the issue of whether they were independent committees under the Campaign Finance Act, does the project and the fund at least agree that they did not disclose any contributions to the commission in 2017 and 2018, including those specifically identified in the amended complaint?
We agree that we did not file reports disclosing any contributions during those years. We obviously take the position that the transactions listed in the amended complaint did not meet the definition of contribution under Georgia Campaign Finance Law.
Nevertheless, you agree that there were no, whatever, if you call it contributions or not, the reports were not made for 2017, 2018 to include any contributions.
That's correct.
Okay. The next allegation is that the project and the fund failed to disclose approximately $3,200,449 in expenditures in 2017 and 2018 in violation of OCGA 21534 F2B. Does the commission staff agree with that statement of allegation?
Yes, Mr. Chair.
Without making any admission on the issue of whether they were independent committees under the Campaign Finance Act, does the project and the fund at least agree that they did not disclose any expenditures to the commission in 2017 and 2018, including those specifically identified in the amended complaint?
We do agree with that. The only comment I would make, Mr. Chairman, is just that the failure to disclose allegations that you're discussing right now are not separate allegations from the failure to file reports, right? So the contributions and expenditures that are alleged in the amended complaint would have, they would have been filed in the reports that we've already admitted were not filed.
That's correct. The only reason that I'm bringing this up is that those were new allegations in the amended complaint, and so I just wanted to make sure that they got addressed. I don't disagree with you that those would be, I guess, a sub-allegation to the allegations that we already covered, but I just don't want there to be an issue.
Sure.
Okay.
Thank you.
It seems to me, and I'm not going to ask anyone to necessarily agree or disagree with this, but based on everything that I've just seen with regard to what I've called primary allegation number one, that it all comes down to a question here of whether there is reasonable cause to believe that the project and the fund were independent committees under the Campaign Finance Act as it's defined. Is that agreeable as to what the primary issue is going to be on that first issue, on the first question?
We agree with that.
Yes.
Okay, all right. Again, I know that was tedious, but I think it's good for us to actually get it narrowed down to what the question is that we're going to be looking for. All right, now I'm going to go through, again, I just want to make it clear for the record, primary allegation number two. That's again my label. It's that the project and the fund failed to register and report as ballot or campaign committees. I understand that the definition of this ballot committee is a sub-definition of campaign committee. Is that right?
Yes, it's A2. It's a term of art is ballot committee. It's for a ballot referendum.
Okay. Does the commission staff agree with that primary allegation too?
Yes, we do.
More specifically, the allegation is,
We agree.
well, as far as that, for the primary allegation, it's just I want to make sure from the staff that that's what it is. The more specific allegation, the project and the fund did not register with the Gwinnett County Election Superintendent as ballot committees in 2018 or 2019 in violation of OCGA 21534A2. Does the commission staff agree with that statement of allegation?
Yes.
Without making any type of admission on the issue of whether they were ballot or campaign committees under the Campaign Finance Act, does the project and the fund at least agree that they did not register with the Gwinnett County Election Superintendent as ballot or campaign committees in 2018 and 2019?
Yes.
I do. Oh, Joe was on it. Joe, what number is you?
11.
Are you okay here so far? The next allegation is that the project and the fund did not file campaign disclosure reports that required of them as ballot committees 15 days prior to the election held on March 19, 2019 relating to the expansion of transit in violation of OCGA 21534A2B. Does the commission staff agree with that statement of allegation?
Yes,
Without making any admission on the issue of whether they were ballot campaign committees under the Campaign Finance Act, does the project and the fund at least agree that they did not file any campaign disclosure reports required of such committees under OCGA 21534A2B in connection with the election held on March 19, 2019?
Yes.
The next allegation is that the project and the fund failed to disclose approximately $646,422.89 in contributions in 2018 and 2019 in violation of OCGA 21534A2. Does the commission staff agree with that statement of allegation?
yes, we do.
Without making any admission on the issue of whether they were ballot or campaign committees under the Campaign Finance Act, does the project and the fund at least agree that they did not disclose any contributions to the commission in 2018 or 2019, including those specifically identified in the amended complaint?
That's correct. We did not file reports.
The next allegation is that the project and the fund failed to disclose approximately $173,643 in expenditures in 2019 in violation of OCGA 21534A2. Does the commission staff agree with that statement of allegation?
Yes, we do.
Without making any admission on the issue of whether they were ballot or campaign committees under the Campaign Finance Act, does the project and the fund at least agree that they did not disclose any expenditures to the commission in 2019, including those specifically identified in the amended complaint?
Yes.
So again, it seems to me that with respect to primary allegation number 2, it all comes down to the question of whether there's reasonable cause to believe that the project and the fund would qualify as a ballot or campaign committee under the Campaign Finance Act. Is that,
Correct.
you agree?
Yes.
All right. So again, I know that was tedious, but it boils everything down into 2 real primary questions of what we have to take into consideration here today. Were they independent committees or were they ballot committees? All right. I want to go ahead and address, while we're here now, that the project and the fund have filed a motion to dismiss. I've made the decision that we're going to take up the motion to dismiss before we get into the substantive allegations of whether the 2 groups constitute independent committees or ballot committees. As I read the motion to dismiss, and again, I'm going to ask you if I'm wrong on this, I see 3 different issues raised by the motion to dismiss. Again, I want you to tell me where I go wrong with this. The first argument in the motion to dismiss is that 11 of the 12 allegations in the amended complaint are barred by the statute of limitations. Is that right?
Correct.
All right. The second argument that I see raised in the motion to dismiss is that the amended complaint does not sufficiently provide facts to support its allegations that the project and the fund received contributions and made expenditures within the meaning of the Campaign Finance Act.
Correct.
All right. What I don't want to happen with respect to that argument is I don't want that to turn into a factual issue. I understand from reading your motion that you put forth certain facts in that motion in order to make the arguments in that part of your brief. From my perspective, that would not be proper for a motion to dismiss. So, if you're going to be arguing facts and presenting facts on behalf of your clients with respect to that argument, I'm going to ask that that be moved to the argument regarding the substantive allegations for the preliminary hearing. So I'm going to ask, will you be presenting facts in support of that argument?
Yes.
Okay. Do you have a problem then if we pull that from the motion to dismiss and we add that to the argument, which I'm certainly going to allow you to make, a legal argument in the preliminary hearing? But I think, again, that if you're going to raise facts with respect to that issue, that it's not proper for a motion to dismiss, but it would be proper for the preliminary hearing.
Understood. I think that given the arguments in the motion, it will be difficult to make just legal arguments that are not tethered to any of the factual allegations. I'm happy to separate them as you requested, but I will need to refer to at least some facts at a high level during the motion argument, if that's okay.
Okay, well,
I could try to keep it as
Again,
brief as possible.
what I'm suggesting, and again, I'm suggesting that we just withdraw that argument
Okay.
from our, when we raise or when we discuss the motion to dismiss, and we just reserve those issues for the preliminary hearing.
Okay.
Again, is that agreeable with you? Again, I'm not trying to keep you from being able to make those arguments at all. My point is that if you're proposing, or if you're going to be arguing facts or putting facts, if you're going to be setting some facts forward on this, that's not really a motion to dismiss. If it's a situation, that would be something where it would be like a motion for summary judgment or a motion for summary adjudication or something like that, where you've actually got the facts and then you apply it to the law. If you're having to rely on facts, I'm not sure that that's proper procedurally for a motion to dismiss. Does that make sense?
Sure.
So is that fine to just
Sure.
remove that to the preliminary hearing?
As I understand it, yes, we'll argue the motion to dismiss, we'll make legal arguments during that, and then we can reserve factual arguments for the second part of the hearing today.
So are you still going to be making a legal argument relative to that point?
Yes, yes, absolutely.
All right. Well, if you start bringing up facts, then we're going to stop and move that to the preliminary hearing.
I understand.
Agreed? Okay. The third argument that I see in the motion to dismiss is that the commission lacks jurisdiction because your clients don't have the major purpose of influencing elections.
Correct.
Again, I'm assuming there that you're going to have to put forth factual allegations regarding what the major purposes of your clients are. And if you're having to set forth facts in that regard, from my perspective, that wouldn't be proper for a motion to dismiss. It would be proper for discussion in the preliminary hearing.
So our argument with respect to that piece of the motion is actually just that the amended complaint does not allege that my clients have the major purpose of influencing an election. So there actually are no facts that are needed to rebut that. It's simple. It's based on the text of the amended complaint, which does not contain that allegation.
Okay. So it's not, I see, okay, that's fine. All right, and does that address did I go through the motion to dismiss, or are there other issues? Those seem to be the three issues that were raised in that.
Correct,
Okay.
yes.
All right.
Thank you.
The last thing that I've got in our packet that we looked at in this is a motion that you filed to protect the donor information from public disclosure. Is that right?
Correct.
All right. What I'm going to do is I'm going to take that up right now. I think that we need to go ahead and just hit that now before we get into anything else. That's your motion, and so I'm going to go ahead and I'll hear your argument on the motion to protect the donor information from public disclosure.
Okay, thank you. Should I use these microphones or?
You can go to the podium. I have your table mic on, but
I don't think it's close, thank you. Good morning, Commissioners. My name is Aria Branch. I'm from Elias Law Group. I'm here with my colleague Emily Hogan and my co-counsel Brian Sells. And we represent the New Georgia Project and New Georgia Project Action Fund. Thank you very much for taking the time to hear our motion to protect respondents' donors from public disclosure at the outset of this hearing. And I think it's really important that we are addressing it at the outset because, as we all know, this is a public hearing. It's publicly recorded. It is open to the public, which means that if our donors are stated, their specific names of our donors are stated during this hearing, they will be publicly disclosed and made publicly available information. At this point, New Georgia Project and New Georgia Project Action Fund are not required to publicly disclose their donors. They are nonprofit organizations who report with the IRS. They file yearly tax returns. And under tax law, under federal tax law, as 501c3 and 501c4 organizations, they are not required to publicly disclose their donors. They will only be required to publicly disclose donors if the commission makes a final determination that they were required to register and report as campaign committees and as independent committees under Georgia law. Even then, they will not be required to disclose all of their donors, only those who gave for the purpose of influencing an election. But the important thing to keep in mind is that that legal determination has not yet been made. That is the reason why we are here today. As the chairman just discussed, we are here today to here for the commission to make a determination on those dispositive legal questions. Whether NGP and NGP Action Fund were required to register and report as campaign committees and as independent committees, and thus required to disclose their donors. Until that decision is made, they should not have donors disclosed publicly. It would be putting the cart before the horse, and it would cause the organizations irreparable harm. Because once their donors are disclosed here today, you can't put the cat back in the bag, right? So their donors are stated publicly here today, and then the public will have that information. It's not that we are trying to hide who supports these organizations, but we're not required legally to disclose them unless and until the determination is made that we're required to register and report as committees under Georgia law. And I just want to state, I think it would cause the respondents irreparable harm to have their donors publicly disclosed here. It is not necessary on the other side of the equation for the commission to state the specific names of respondents' donors in order to adjudicate the issues that are before you today. We're not asking that the commission staff is not able to name the types of organizations, for instance, who contributed to NGP and NGP Action Fund. They can certainly make general references to the organizations, but it's not necessary to name specific donor names in order for the commission to make a determination here today. So as a practical matter, it's just not necessary. And so we would ask that the commission grant our motion so that respondents' donor names are not publicly disclosed in violation of their First Amendment rights and in violation of their donors' First Amendment rights, which are protected. I reference in the motion the case Buckley versus Vallejo, which we'll discuss in detail later, but it essentially states that unless the organizations have a major purpose of engaging in political activity, they are not political committees under the law. Again, that determination has not yet been made, and so we would ask that respondents' donors are not publicly disclosed until a final determination is made on that dispositive legal question. I'm happy to answer any questions that the commissioners have.
Any questions before we hear from Mr. Cusack? Mr. Cusack?
So commissioners, just first off on this issue. This issue was raised in Gwinnett County on the motion to quash for the bank records there, and the court rejected that. So I just wanted to get that out first, that this issue has already been raised in Gwinnett County on the motion to quash for the bank records, and the court rejected this argument. There was another case that was cited in...
Mr. Cusack?
Yes.
On what grounds?
Well, there is an analysis that's done, and let me just reference the case law on this, that there must be a reasonable probability that compelled disclosure of contributors will subject them to threats, harassment, reprisals, things of that nature, and there was no finding by the court that any of that had been met. There's a couple different arguments.
Mr. Cusack,
Yes.
while we're on this, I guess I don't understand. Are you saying that your argument, when we get into the details, is going to rely on the specific people that made contributions to a 501c3 and a 501c4?
Some of the organizations, and some of these are going to be via Act Blue too, so to close this off, I think it's not going to give a full picture of the case if we do this.
By not mentioning the specific names, you think it won't give a full picture?
And I don't know if Ms. Branch can correct me on this, are you referring to specific names of people or organizations as well?
Both.
Okay.
Well, I think it has to apply all the way around. Because one of the reasons that people use 501c3s and 501c4s is because of the anonymity. I mean, these people, because we haven't ruled that they're independent expenditure, I don't know how your argument can be that the names are that important if we haven't identified that they really were an independent committee or ballot measure unit.
Well, and I'm citing some of the case law here in that I'm referencing that Gwinnett hearing where this argument's been rejected, and then bringing in, they referenced Bonta, It's a Supreme Court case. It was Americans for Prosperity v. Bonta. As a case on point, and that was a nonprofit compelled disclosure law in California where the highest donors for nonprofits had to be disclosed to the Attorney General in California. And the Supreme Court held that the First Amendment right was not narrowly tailored to meet an important government interest there, and that California tried to argue that the state needed this interest to prevent charity fraud. Now, in this case, it's distinguishable.
Commissioner Watts.
Mr. Cusack, I guess, to the commissioner's point, why is it important, like now, for the disclosure?
So this is political speech, and we're alleging it's political speech. And without this information, I don't think the commission is going to be essentially not being able to put on their case the way they see fit. And also, all this information already is contained in the amended complaint. There's not going to be anything new that is in this presentation that hasn't already been alleged in the amended complaint.
So that if we were to rule in favor of the project and fund in short term, or shorthand rather, if we were to rule in favor, what would we be doing differently right now? Since the information is already included in the amended complaint. I mean, you're going to say the names regardless, right? I mean, you've already said it.
Yeah. But
Yes, yes.
I think the point is that we've seen it, but the public has to see it. If he
Got it.
says it out loud, then the public hears it.
But the amended complaint is subject to the Open Records Act.
Would it have to be?
Wait a second. This is what I want to bring up. That's the problem that I see, at this juncture, is I'm not sure that, any member of the public couldn't just come and make an Open Records Act request at this point and request the records that were obtained via the subpoena, or request what's in the amended complaint, because that information is set out in the amended complaint. I don't know of any exception that would apply to that. I mean, again, I haven't examined it in detail to look at that, but that's, you made reference, Ms. Branch, in your argument to, I guess, to the cat being out of the bag. I'm not sure that it's not already out of the bag. Commissioner Hick?
So, I mean, my position is that if, let's say, the defense prevails and you disclose the names, and to the council's point, it irreparably harms those folks, I'm still struggling with why is it necessary to do that now, disclose names, as opposed to just waiting until a ruling is made.
Well, part of my argument is that there's nothing that's in the amended complaint is already subject to the open records request. There's nothing in there that further discloses who the people are. So there's nothing that addresses, phone numbers, things like that. So this information is already subject to the open records. It's information that's already there, and that's what we're incorporating into our presentation.
So from my perspective, I'd rather them go ask for the open records request as opposed to us doing something that we may later decide that, does cause harm.
Commissioner Thompson?
And this may be for the executive secretary. Is the staff providing complaints and amended complaints prior to it be adjudicated in front of the commission? And if so, what is being redacted and what is not being redacted? Because this would set a dangerous precedent. Anybody could file a complaint against a 501c3 or 501c4, and then the commission would get the records, and then somebody does an Open Records Act. This is a very dangerous loop around.
So, first, to your point of anyone can seek, first of all, the commission doesn't just seek subpoenas of 501c3s or c4s without evidence that they're engaging in political activity. The argument that those records should have been redacted were properly before the Gwinnett County Superior Court and the Court of Appeals, neither of whom chose to redact those records. At that point, they were incorporated to supplement the amended complaint, which there was a motion originally filed that the original complaint did not sufficiently put the respondents on notice as to the violations. So the amended complaint used the records that were obtained to supplement the allegations in the complaint with more due process, allow them to be aware of what the specific allegations of the violations of law were. Now, to your question about anyone can file an Open Records Act, the complaint and the amended complaint under the Open Records Act are subject to public disclosure within 3 business days of any request, prior or post adjudication.
Without redacting.
Without redaction, and there's no exception for that. Now, we did take note to redact any bank account numbers in the amended complaint, but there's no provision to redact that information in the amended complaint. And to say that we should not have included in the amended complaint, we would have been in the posture where their original motion to dismiss was they haven't provided us enough information to be aware of the allegation we're on notice of having violated.
Well, and again, let me be clear, I'm not saying that, I understand the importance of the staff to see those, not the public.
Mr. Watts?
What exactly, without naming names, are you going to need to do to present the substance of your argument later with this information that they're seeking to keep private?
Can you expand on your question a little bit?
Yeah, exactly. So you said you need this information to present your case, right? So they're trying to keep certain, right, debtors private, which I understand. But what are you going to need to do with that information to present the substantive argument later?
So one of the defenses here is that some of these, some of these contributions were not earmarked, and we're going to show some specific transactions that we believe would actually be earmarked for political activity. So that's one of the reasons why.
And you need to name the entity or individual?
Well, and those are going to deal with Act Blue mostly. So it's just to be able to get a full picture for this hearing.
I mean, I understand that, but like so in my head, if you put up a slide, for instance, and it was, redacted, the name, would whatever you're presenting still come across even with the redaction? Or do you need the name?
I think it's going to lose some of. I think it's going to lose some of the point of all this, of the contributors and how many there were. I would like to be able to present the case in full. I think that's important. I understand your concern, but it's tough to just try to sort of kneecap my case again, if that makes sense.
I guess maybe a better way to phrase the question is to explain your argument about whether the project and fund were independent committees. Do you need the name of the entity or individual to help do that?
Well, and I think that comes back to some of their arguments. They're saying these contributions aren't for political purposes or aren't to influence the election. Some of these communications are going to be, that are asking for money, are inherently political. So I think there is something lost when these contributors or contributions aren't named.
Commissioner Hicks?
I'd like to ask Ms. Branch a question. If the information is already public, why are you opposing it being disclosed here? If it's already open records, why are you opposed to it being disclosed?
May I approach
Your microphone's on. Or you can go up there, it doesn't matter.
Okay, I would like to just.
Sure.
So I think that your question earlier, Commissioner Hicks, hit on a really important point, which is there is a difference between an amended complaint being subject to disclosure pursuant to the Open Records Act, meaning that an individual has to actually make a request to the commission for this information. That hasn't happened. It's completely different than disclosing the individual name. the individual names of respondents' donors in a public hearing where the press are here. I understand it's being publicly recorded and will be made publicly available on the commission's website and posted. There's just a fundamental difference between those two scenarios. And I would also like to reply to some of the other arguments
So
that.
before you do that,
Sure.
That means that the press can go ahead and do an open records request right now, right?
I understand that,
Yeah.
but individual, that hasn't happened as far as I understand. They're not publishing individual names of donors. It hasn't occurred. And on the other side of this balance, there is no reason to name the specific donors of respondents during this hearing. And Mr. Cusack has essentially admitted that. When you asked the question, he said, I think it's going to lose some of our point if we can't name specific names. The commission chair at the outset of this hearing set forth the specific allegations that are being discussed today, and the issues are pretty narrow. It's just whether or not these organizations were required to register and report as committees. Nothing about the specific names of their donors will have any bearing on that. And I think that Mr. Cusack has essentially admitted that. It will not hurt their case to be foreclosed, the commission staff's case, from if they are foreclosed from stating the specific names of donors. I think they can make their arguments just as well. On the other hand, respondents will suffer due process violations, and it will cause them irreparable harm if their donors are disclosed here today.
Can I ask a question? What's the irreparable harm if it's already subject to open records? Any one of them could have texted by now and asked for these names.
There's no indication that that has occurred.
No, you said irreparable harm. What's the irreparable harm if we don't disclose the names? If Mr. Cusack doesn't disclose the names today? Because they're already out there, subject to open records.
Well, I would argue that they're not out there. And they're not out there in the same way that they would be if they are disclosed during this hearing today. And then immediately after this hearing, a video of this hearing is posted on the commission's website. They're not out there in the same way. They haven't been disclosed. And as Commissioner Thompson indicated earlier, part of the reason that donors give to 501c3 and C4 organizations is because they will not be disclosed. And until the legal determination of whether they qualify as committees is made, their donors should not be publicly disclosed. I think it's unfortunate that the amended complaint is subject to disclosure under the Open Records Act in the first place, because as Commissioner Thompson indicated, it creates a huge loophole in the law, where essentially an individual could file a complaint and then make an Open Records Act request or the commission could file a complaint including the donors, the specific names of a 501c3 organization, and then individuals can make Open Records Act requests and obtain that information before a legal determination is made. I think it will cause a severe due process violation to disclose the donor names today, and it's just completely unnecessary to adjudicate this matter.
But as I understand it, your relief that you're seeking is just to not disclose the names.
To not publicly state the names during today's hearing, which I think is a reasonable request given that it's not necessary to adjudicate the legal issues.
And you're not seeking to redact the amended complaint.
We will file a motion that
But you
will,
have not done that.
we have not done so
And
yet.
so the only thing you're seeking today is to not disclose the names today.
Correct. But we will file a motion.
Understood.
Okay, well, thank you.
As you stand here today, do you know of any exception to the Open Records Act that will apply to prevent the disclosure of this if we got a request for it?
I am not aware of an exception that would apply to this to protect the names of the donors, but I think as the executive director indicated earlier, the specific information related to them, such as their addresses, banking information, I do believe that would be redacted under the Open Records clause.
And I'll ask Mr. Imadi, to this point, has the commission received any Open Records Act requests for this data, for this information?
Yes, from multiple media sources.
For the names that are in the...
No, for the amended complaint in its total, which includes those names that were alleged.
So has it already been provided?
to at least 3 to my knowledge.
Okay. Any other questions or comments for anyone with regard to this motion?
I have one question for
Commissioner
Mr.
Burns, go ahead.
Cusack. I was not on the commission when the state court litigation, I just wanted to be clear, there is the list of names in the amended complaint, which I've read. That's the list. There's not other names that there's not a second list somewhere.
Correct.
All right. I have some sympathy, actually a lot of sympathy for the argument. I'm struggling with the mootness issue because it's out there. Given that we are in a public meeting now, I guess this is more of a legal question. Can we grant the relief that they're asking for and not run afoul of the Open Records or Open Meetings Act? Because we'll hear from the press if we do.
I think that's a legitimate question. Just because this information, essentially, we're talking about the cat being out of the bag. The cat was out of the bag, and I don't intend to present any more information than what's already in the amended complaint in regards to names or anything like that. So that's solely what's contained. What's contained is in the amended complaint is there.
Commissioner Thompson.
Stop talking.
This could be a question for any member of the commission or the executive secretary or Mr. Kuzo, Ms. Branch. Let's say we do not find that they had a responsibility to register and report. Then if then if there was an open records request on the complaint, would the names then be redacted?
No.
They would not.
There's no exception under law for that. And if I may add, there's been some consternation about 501c3s and C4s and their donor list becoming made public, and I understand that concern. I think we're almost treating this as if there's been no opportunity for recourse on the respondent's part. They raised this issue seeking to shield the donor list in Superior Court. And part of the requirement to do so is to show that there is a risk of harm and irreparable injury, and the court's found none. That's part of the requirement in justifying that shielding of disclosure, and a court of law has already said that doesn't exist here.
Wasn't that to quash this?
Of the bank records that included their donor
Well,
list.
I agree with that.
Yeah.
I agree with the court part.
Yeah, but what the executive secretary is saying is that part of the argument that was raised in support of quashing the subpoena was that it was going to cause irreparable harm to the donors and to the clients with regard to who the donors were, and the court rejected the argument.
So that's what I was asking earlier, and you said this sort of legal grounds, but what was the basis? Why did the court find that there would be no irreparable harm?
It found no showing had been made that there would be irreparable harm, that any sort of threats or anything like that, like I mentioned previous on that standard, had been met.
But I know, but why?
They have to provide it. They have an affirmative obligation.
Did the court elaborate at all?
It just said it did not find that burden had been met.
Okay.
But there's no dispute here, I guess, that the burden with regard to this motion is going to rest with you. Or your clients.
We are good with Mike, yes. My co-counsel, Mr. Sells, would like to raise a couple of additional points.
Sure. Just the cat out of the bag argument. Some of you may recall about 5 years ago, there was an open records request for voter lists at the Secretary of State's office, and the Secretary of State's office erroneously sent out a CD with confidential information on it, and the cat out of the bag argument didn't prevail under those circumstances. The media organizations who had requested and received the erroneous voter lists had to give them back. And Mr. Ahmadi is aware of the organizations that have requested the...
I don't want to interrupt you, but my only thought on that is, in the case that you're talking about, that information was erroneously provided. here, there was no information that was erroneously, released to anyone. It was properly provided under the requirements of the Open Records Act.
Well, respectfully, I think if this commission decides to protect that information, as it should, for the reasons that Commissioner Thompson suggested, then it was in fact erroneously provided and should be and could be clawed back from the media organization.
I asked the question, give me the exception that would apply to providing the information in response to an Open Records Act request.
Well, we can offer further briefing on that, but there are exceptions.
That's not gonna do us any good.
15-18-72.
That's not going to do us any good because we're having the preliminary hearing today. I'm sorry, it should have been something that was in the motion. Go ahead.
Yeah, this is why I pointedly asked the question about, did you file the motion to redact one of you? And you didn't. And so, yes, if we, find otherwise today, then certainly we could claw it back, like you said. But as it stands right now, all of that information is subject to the Open Records Act. And has apparently been provided to media sources.
Sure. I think your suggestion that we haven't asked for that particular relief elevates form over substance. We can make the motion.
Well, I've been here for a few years,
right
and
now.
I've been asking time after time for people to file motions that they're seeking certain relief before they get in here, from the staff and respondents. So I've been very clear that if you want us to rule on something, file a motion, make the argument before you get in here.
Having just learned at this hearing that that there have been requests for this information and that it has been provided to the media, we would like to make that motion. Okay, that the commission not only protect disclosure today, but also deem that the donor names in the amended complaint are confidential materials exempt from disclosure under OCGA 50-18-72 and ask that those materials be clawed back until such determination has been made that they are not confidential.
All right, well, in support of the verbal motion that you just made there, I believe the Open Records Act requires someone to actually identify the specific subsection of the act that you're going to cite with respect to not releasing those documents. So what's your subsection?
Well, again, having just learned a few minutes ago that the materials in the amended complaint were disclosed, I would need some time to do that. I can't do that on my phone, on the fly.
Okay. All right, I'm going to go ahead and
We could take a recess, and I'd be happy to do that. I probably only need 15 minutes.
I've got a question. So how long since the amended complaint was served on you all did you know that the information was contained in the amended complaint and subject to the Open Records Act?
To be honest, our understanding with respect to the processes that the commission follows is that documents that are part of an active and open administrative proceeding like this one, are not subject to the open records request until the matter is closed. And the reason for that is because of the arguments we're making here today. A legal determination on these organizations' status has not yet been made. So it doesn't make sense to disclose their donors to the public before the commission has determined whether or not they were required to register and file reports disclosing their members to the public. We just learned today that the amended complaint has been disclosed publicly. We didn't know that previously. And we're also under the impression that these documents would not be subject to the open records request until the administrative matter had been resolved.
What gave you that impression?
That is my understanding about how administrative proceedings work to protect the due process rights of organizations like my clients.
But is that based in law?
Like my co-counsel said, we need to take a look at the exceptions to the Open Records Act, but it does not, whether it's based in law or, certainly it would be based in law. But
Well, I'm
we
asking,
can take a look at the exceptions because we do think there would be a basis to protect these documents from public disclosure before the dispositive legal determination has been made.
but I guess you're understanding that it would be protected prior to now, even with the amended complaint containing the information that it was served upon you all, I assume. That was just your impression.
That's my understanding based on Georgia law. And like I said, we can take a look. If you would just give us a brief recess, we can take a look at the exception that we think would apply. But, you know, look, the amended complaint in this matter is distinct from other matters. In this matter in particular, the amended complaint includes all of respondents' donors. That's not true in every matter that comes before you all. The amended complaints that come before you all often don't, I would assume often don't include all of an organization's donors. So, you know, I don't think that the specific identity of our donors is relevant to the discussion here today. And I think it would make sense to grant this motion to protect our due process rights, which you can't undo. I said we will file a motion to protect our donors from public disclosure under the Open Records Act, and we believe we will prevail on that. But we haven't done that yet, as you have stated, and we will do so.
Commissioner Thompson. So the names are protected under federal law if it's given to a 501c3 or 501c4. Is that not true?
Accurate.
Okay. So I guess I don't understand, if a member of the public has to file a complaint, and they have to have knowledge of something that went wrong to file a complaint. That's what they're alleging. They actually have to have actual knowledge. All right? So what the commission staff has started doing in the last couple of years that has never been done before is they go further. They have a complaint and they go further. And then they start issuing, or may issue, I know you're going to do it all the time, subpoenas. That they get information that members of the public would not get. And I guess I don't understand, and I've been in criminal justice and have degrees in it for a long time, how, if names are protected under federal law, an administrative agency who does have subpoena power issues subpoenas for evidence, how that circumvents the protection that the federal government gave to these people who were given to a C3 or C4. We're an administrative agency.
Well,
I guess that's where my confusion is, just a lay person that's not an attorney.
and I think that's a fair question, but I think you're incorrect in your assumption. And I think Mr. Cusack has case law on point that says federal nonprofits who assert their major purpose, and this is getting a little ahead,
But we haven't decided.
but this answers your question. There's case law that says that nonprofits who assert their major purpose is not political activity are still subject to state finance filing requirements if they engage in political activity. So the assumption that they're just completely protected from disclosing these donors it's not accurate.
But it hasn't been determined yet. I understand all these names could be public immediately if the commission found that they should have registered before.
We would like to just raise, if I may, a exception to the Open Records Act under Georgia law. This is OCGA section 50-1872 A4, which provides an exception from public disclosure for records of regulatory agencies in any pending investigation.
Right, it's the one, it's until 10 days after the investigation is concluded.
Right, and this investigation is not yet concluded.
Well, I think, I mean, I'll ask the question, was the investigation concluded with the event when it was filed?
Concluded in the sense that we allege that it's going to be probable cause, yes.
Right.
The law says that the investigation is deemed to be concluded when all direct litigation involving such investigation has become final or otherwise terminated. We're not at that point yet.
Say that again?
The law says that the investigation will be deemed to be no longer pending when all direct litigation involving the investigation has become final or otherwise terminated. And we're not there yet. We're a long way from there. So the amended complaint should never have been disclosed. It should have been withheld under this exception, and it should be clawed back.
What's the language you just read?
It is.
Sorry, no, yeah, I don't need to read it again, we just
Yeah,
cite it.
Yeah, it's 50-18-72, subsection A4.
And Commissioners, I have the whole statute in front of me. I don't know if you would like me to read it, but it seems that this is discretionary versus absolute.
Can you explain that to me?
So, do you want me to read the statute?
That's why I want to explain to me, why is it discretionary if it's still on?
So, in regards to, we have the authority to release our complaints, which we do in the effort because transparency is in our name. So, we have the authority.
It's a little name, just so you know.
So, I'm just saying that it's on the agency's discretion.
And the law specifically says that. You don't have to read it to me. I believe you.
Says,
It's discretionary, but that gives us a reasonable basis for believing that the amended complaint would not be disclosed with those donors.
And I would point the commissioners to subsection A, which says public disclosure shall not be required. So that doesn't indicate discretion at all.
I have our open records officer right here. You may want to hear some more information.
I didn't hear what you said.
Oh, I was going to say, Mr. Lane's the open records officer. If he's much more.
Well, if he wants to make a comment on it, go ahead.
Commissioners, it's been the position of commission staff, at least for the past 8 years, so this is not a new development in our practice and procedures in responding to Open Records Act requests. Under Georgia's Open Records Act, which has been cited to you, it's discretionary on the agency's part whether to release parts or all of its investigative file. It's not mandated in law that we shield information. Now, we don't release our entire investigative file. We don't find that to be good for either respondents or for ourselves. We're not going to try the case in the media. But what this commission has done for the past 8+ years is to release any complaint that is filed, whether it's by a third party or by us, and to release any response that comes from a respondent. That's what we release. We don't release bank statements. We don't release other evidence we get by subpoena until it is presented in an open meeting before this commission. So until it's publicly presented to this commission, we will withhold it, with the exception of the complaint, any attachments to that complaint, and then any response and any attachments to those responses. Additionally, in any notice of hearing that we provide to the parties, we give an explicit disclaimer that everything we do at these meetings is subject to the Open Records Act and the Open Meetings Act. And we are presenting the complaints and the responses at the open meeting, so it's not a surprise. And we have not deviated from our standard practice, which we've been doing for the past 8 years.
Commissioner Watts.
just to cut through this and move along. Mr. Cusack, can you just use like party X or party Y, and if you think that it's gonna hinder your ability to present your case at any point, then we can address that. But right now, we don't have a motion to call back the information. So that's not pending. And we have a motion to protect the information today. Can we just move this issue and move on to the substance if we can avoid the names for right now?
And I can, if I see an area where
I understand that, and I
Okay.
want you to tell us.
And-
I mean, I get it.
I think that's fair, and if I see the headache that this is causing, and I'd rather just get to the substantive issues here, because I think they're very compelling. So-
Because to the commissioner's point, I mean, we're gonna have a whole callback issue depending on how we rule. So, you know, if we can just kick the can for, that'd be great.
And I just need a little bit to make some reactions and figure that out.
What, you mean in the materials?
Yes.
The slides or the stuff that you gave us?
PowerPoint slides.
The slides, we're
Yeah.
sorry. We're old.
Yeah. How long do you think that'll take?
In 10 minutes.
Okay.
That's fine.
I mean,
No, that's fine.
And I don't know if maybe a natural break point would be, I know there's
still have to make an argument.
the legal arguments, and then
Sure.
maybe that's what.
Just hold on one second, Mr. Sells. The verbal motion that you made with regard to, accepting them from disclosure, accepting the amended complaint from disclosure under the Open Records Act, you made that orally. Is that something that you can, present by motion? If we follow what Commissioner Watts has proposed here, that we just don't mention the names today during the hearing?
If you would like us to present it in a written motion, we can do that.
Well, I'm just saying that otherwise, I don't think that we've got a motion to rule on with regard to that here, because we haven't had it briefed as to that section of the Open Records Act. We haven't had to get, the staff hasn't had an opportunity to brief that. I mean,
So I'll follow up again. I hope I'm cutting through this and we can move on, right, if we just don't mention it today. I understand your position. I frankly didn't know it was disclosed before the hearing either, but I also, as I asked the question, it's not that this was a shock that this was subject to the open records. It has been since you were served the amended complaint. So whether you agree with that or not, it has been. So in any event, if we don't mention the names today, can we get to the substance?
Yes, and we can file a separate motion related to the.
That's fine.
owner.
And y'all are welcome to do whatever
Yes.
you want to do with that regard.
Yeah.
so we're going to move that motion then by agreement of the staff that they're not going to mention that during the hearing today, which is essentially what you asked for. Unless something comes up and we have to deal with that specific topic. Is that good?
Yes.
All right. Can we go into the legal issues of the motion to dismiss now, or do you need to go ahead and do what you need to do?
What I would propose, and it's totally up to y'all, handle those, and then if you give me 10 minutes after that, I can,
That's fine.
okay.
All right. Ms. Branch, we're going to go ahead and move then to the arguments and the motion to dismiss. The first argument that I understand was raised was the statute of limitations, so we'll go ahead and hear from you on that. We're actually going to handle this all together. If you just want to make your arguments with regard to the motion to dismiss, we're not going to break those up into different parts.
All of the motion to dismiss, but not the factual argument.
That's right.
If I may have the PowerPoint, how do I put that up?
Irwin?
Yes, I gave it to her.
Sure. Joe, just, we know what Irwin does good on that one as well. No. We're trying to find
let's go ahead and, when you're ready.
Okay, thank you. I do have copies of the PowerPoint presentation for your reference, and those to Mr. Kisak and to each of you, in addition to 2 other materials. I'll go ahead and begin. I would like to start with just a little bit of background to sort of set the stage for the motions to dismiss. Starting with some factual background on the 2 organizations that are the respondents in the matter today. The first is New Georgia Project, which is a 501c3 public charity. The second is New Georgia Project Action Fund, which is a 501c4 social welfare organization. Both organizations are nonpartisan voter registration and voter engagement organizations. They are not run for the primary purpose of electing or nominating candidates to office. They seek to make it easier for people to vote and to have their votes counted. They help people get involved in their government. They focus on underrepresented and historically disadvantaged populations, Black, Latinx, Asian American, and young voters. These organizations have done and continue to do exceptional work here in Georgia. NGP, for example, has registered more than 500,000 new voters in Georgia since 2014. The organizations are regulated by the IRS. As we stated earlier, they file Form 990 tax returns, which publicly disclose their spending, but not their donors. NGP and NGP Action Fund are separate organizations. They are related, they are affiliated, but they are separate for all intents and purposes. They have separate bank accounts. They have separate incorporations. They were separately incorporated. NGP existed before the Action Fund. They have separate EINs, separate boards and bylaws, separate websites, and they act in the public separately. They are affiliated, as they can be by law and as is common amongst nonprofit organizations. And the reason this is important is because, as you see in the amended complaint, the organizations have essentially been conflated. There is a long list of transactions from bank accounts, and it appears that the commission staff have merged the bank account information for both organizations, despite the fact that they have separate bank accounts. And I would like to point the commissioners to a fact sheet we provided just now from Boulder Advocacy, which is an organization that provides guidance to nonprofit organizations. This document is entitled "The Practical Implications of Affiliated 501c3s and 501c4s." It talks about establishing 2 separate legal entities. It says that a 501c3 and C4 can be affiliated, but they must separately incorporate. This includes having unique names, although they can be similar, as is the case with NGP and NGP Action Fund. The fact sheet specifically asks, can a 501c3 and C4 share employees, office space, and equipment? The answer is yes. They may share employees, office space, and equipment. In fact, the affiliated organization can have one staff that divides its time between the 501c3 and the 501c4. And so I just want to establish and make very clear that the setup of these organizations is common. They're affiliated entities, but there's no reason to not treat them separately or to pierce their corporate veil or treat them as alter egos of one another. They are not. And I have included the names of some examples of other affiliated 501c3s and C4s, such as the Heritage Foundation, the Heritage Action for America. So those are affiliated C3s and C4s. They have the same setup. They're not treated the same for legal purposes. In terms of the procedure and how we got to where we are today, we first received 2 complaints in this matter in September 2019, which was nearly 3 years ago at this point. One complaint was addressed to NGP, the other was addressed to NGP Action Fund. The complaints made the same allegations that the amended complaint makes, that the same allegations that the chairman reviewed earlier, that these organizations were required to register and report and failed to do so. Along with those complaints, we received subpoenas directed to each of the organizations. Both of the organizations responded to those subpoenas, producing documents and refusing to produce their bank records. We know, because we lived through this and we've discussed here today, that our motion to quash the subpoena for bank records or to narrow it was denied. And so the commission staff did obtain access to NGP and NGP Action Fund's bank records. We did also request dismissal of the earlier complaints that were filed. We also filed motions to dismiss. Mr. Cusack made reference to those responses earlier. As to my knowledge, they were never considered by the commission or resolved. The amended complaint followed on June 27th, and then of course we're here for the preliminary hearing today. The legal standard that applies and why we are here today is to determine whether there is a reasonable basis to believe that NGP and the Action Fund violated Georgia law by failing to register and report. This is not a coordination investigation. That's not what we're here to talk about. There is a separate, as I understand it, investigation related to coordination, but the history of NGP and the Action Fund, any relationship they may have to Ms. Abrams, is not relevant for today's discussion and not within the scope of the amended complaint. The standard that is provided, whether there's a reasonable basis to believe that these organizations violated the law, is not explained under the commission's rules. We did, however, look to the FEC, which has a very similar administrative process to the Georgia administrative process, to get more information about what standard applies at the same point in time in the FEC administrative process as would apply at the same point in time we are here. And the FEC has stated that it can only find reason to believe that a violation has occurred at this point in time if a complaint sets forth specific facts, which if proven true, would constitute a violation. NGP and NGP Action Fund, as I stated earlier, are separate organizations. There should be a separate finding with respect to each organization. If there's reasonable basis to believe that NGP violated the law, that does not automatically mean that there's reasonable basis to believe that NGP Action Fund violated the law. They should not. At the motion to quash hearing in 2019, there was an argument that the organizations should be treated as alter egos of one another. I hope that providing the explainer from Boulder Advocacy helps with showing that the organizations are affiliated, but they should be treated separately, and a separate finding should be made with respect to each organization. This isn't a situation where the alter ego doctrine applies, which really applies in corporate context, as I'm sure you all are familiar with, where an individual accuses a corporation of engaging in a misdeed, and they want to sue the individuals associated with the corporation or the corporation's shareholders. There's no allegation of misdeed by any individuals associated with NGP or NGP Action Fund. The alter ego doctrine just simply doesn't apply. And there's nothing under Georgia law that would indicate that the corporate forms of these two organizations should be collapsed.
You need facts to show that though, right? And again, I'm just trying to be careful about getting into our probable cause hearing with regard to the motion to dismiss, but when you're talking about, you know, that you can't treat them as alter egos and whatnot, you've got to make factual representations in that regard, right? I mean, that's not going to be just a totally, I understand that there's a legal argument involved, but you have to have facts to support the legal argument.
Right. Understood.
I'm just trying to get to the legal issues that are reflected in the motion to dismiss.
Sure. And I will get to those now that we've set forth the standard. So as I mentioned, the commission staff obtained all of NGP and NGP Action Fund's bank records. They obtained copies of their checks. They obtained copies of every deposit and withdrawal for each of these organizations over a 2-year period. And yet, this amended complaint is what the commission has come up with based on all of that information. This is a complaint that does not distinguish between transactions made using an NGP bank account from transactions using an NGP AF bank account. Even though it is clear that they had 2 separate bank accounts, it is extremely misleading, the amended complaint on that issue. This is a complaint that does not tie a single factual allegation or exhibit to NGP accepting a contribution or making an expenditure as those terms are defined under Georgia law. This is a complaint that asks the commission to presume that just because a transaction was made during an election year, it must have been made to influence the election. This is a complaint that alleges that payments that were clearly made for operational costs, payments, for example, for dental insurance, were expenditures for political purposes under Georgia law. This is a complaint that lists payments to individual canvassers pursuant to vendor contracts and calls them expenditures, even though we have previously argued, and it's been before the commission since 2019, that the Action Fund was acting as a vendor for PowerPack Georgia with respect to canvassing activities. You may recall that when I was before you a couple of years ago, Commissioner Watts, you directly asked me when we were discussing the motion to quash the subpoena for bank records, if the commission can't go through the bank records to determine what is and isn't political as part of its jurisdiction, who makes that call? Well, the commission got the bank records, and they still have not undertaken that analysis. They still have not gone through the bank records and determined what is and is not political. Instead, they provided an amended complaint that produces an indiscriminate list of transactions that were made during election years, and it calls them contributions and expenditures without any evidence or any support for the allegation that they were made for the purpose of influencing an election. The amended complaint should be dismissed. And there are 3 reasons that we lay out in our motion that support dismissal here. The first is that 11 of the 12 alleged violations are barred by the statute of limitations.
Which statute controls here?
I can provide that for you. The statute that provides a 3-year statute of limitations, which is...
That's okay, I just wanted to know if you were alleging that it was the 3 or the 5.
Yes, the 3-year, and it is Georgia Code 21513A.
Okay.
The second reason is because the amended complaint simply doesn't meet the standard. It does not provide specific facts, which if proven true would support allegations that these organizations made or received contributions or expenditures under Georgia law. And I understand from Mr. Cusack's presentation earlier that he is intending to introduce documents that are outside the scope of the amended complaint, and I will make an oral motion at that time to exclude that because I think that will violate our due process. I don't understand how we can be confronted with documents and apparent evidence that the commission has not included in the amended complaint. We can obviously get to that if it becomes an issue, but I do want to set that forth. And the final reason why we have filed a motion to dismiss is because the amended complaint does not allege that NGP or the Action Fund have the major purpose of supporting the nomination or election of candidates, and thus is not, the committees cannot be, the organizations cannot be committees under First Amendment principles. We're requesting certain relief. Our first request is that you vote to dismiss the amended complaint in its entirety. Alternatively, we request that you dismiss the amended complaint against NGP, and as to all alleged violations by NGP Action Fund, except for the one report that is not time-barred. Our first argument is that 11 of the 12 alleged violations are barred by the statute of limitations. And this is the 3-year statute that applies under 21-5-13. Under that provision of Georgia law, an action against a party must be commenced, which is a key word, within 3 years after the date on which the alleged violation occurred. There are only 2 circumstances under when an action is commenced. The first is when a complaint is accepted by the commission, which doesn't apply here, and I will discuss that. The second is when the commission or the Attorney General serves a notice of summons or hearing in accordance with the Georgia APA. That also doesn't apply. We are taking the position, and we believe it is accurate, that a 3-year statute of limitations applies, not the alternative 5-year statute of limitations, which applies only to actions involving a person elected to serve a term of 4 or more years. This action simply does not involve a person who is elected. It doesn't involve a candidate. There are 2 respondents, NGP and NGP Action Fund. There's no allegations regarding the behavior of any candidate. This action has not been commenced under 21-5-13 because in the first circumstance, the complaint has not yet been accepted by the commission. There has been no official action on the complaint by the commission. Only the commission staff have been investigating this matter. The commission cannot accept the complaint until, at the very earliest, after the conclusion of the preliminary hearing, if the commission has determined there are reasonable grounds to believe a violation has occurred. And that has not happened yet, right? We are at the preliminary hearing today. This issue is squarely addressed by the Oxendine opinion, where it very clearly states that commission action does not take place until the preliminary hearing has occurred. The second circumstance in which an action can be commenced is if a notice of summons alleging a violation of the act has been served on the respondents. And that notice of summons has to be under the APA. Again, that has not occurred. We have not received such notice of summons under the APA. This matter is not yet a contested case. It is still in the preliminary phase. It's governed by the commission's rules, not by the APA. And the Oxendine matter, again, makes very clear that a notice of preliminary hearing does not meet the requirements of a notice of summons of hearing served under the APA. And we've included statutory language on this slide to Georgia Code 21-5-6, which states, until such time as the commission determines that there are reasonable grounds to believe that a violation has occurred, it shall not be necessary to give the notice by summons, nor to conduct a hearing in accordance with the Georgia Administrative Procedure Act. And that is exactly the language that is used in the statute of limitations section. So what does this mean as a practical matter? as a practical matter, it means that 11 of the 12 violations that are alleged in the amended complaint are time barred. And we included this chart in our motion to dismiss, but it walks through the date of each of the alleged violations and calculates when the statute of limitations expired on each of them. And you will see that for 1 through 11, the statute has run. The final report is the 12th report, which is a supplemental report for activity through December 31st, 2019, which would relate to the ballot measure election. That is the only report that is active before the commission that is not time barred. I think a natural question that you all may have is, well, what about the fact that there was all this litigation in the interim? And it's a fair question, but it did not toll the statute of limitations. There's nothing in Georgia law that indicates that the statute of limitations would be tolled while a motion to quash is being argued. In fact, the commission's rules explicitly provide that respondents have the opportunity to file a motion to quash, and there's nothing that is in the commission's rules that indicates that that would toll the statute of limitations. The same thing was certainly true in the Oxendine matter. Significant time had passed in that litigation, and that did not factor into Judge Walker's decision to find that several of the allegations against Oxendine were barred by the statute of limitations. We've included Judge Walker's decision as Exhibit H to our amended complaint. And importantly, in her decision, as she calculates the statute of limitations, she indicates that the statute was tolled for 122 days due to COVID. She never once mentions that the statute would have been tolled for all of the intervening litigation that occurred in that matter in 2016 and in 2017, including with respect to a motion to quash a subpoena for bank records, which was the exact same litigation that took place in this matter. The commission is required to prosecute its cases timely. There are all sorts of reasons for that. Obviously, the sooner you prosecute a matter, memories are fresher, evidence is fresher, things are not stale. The commission didn't need the bank records in order to bring this matter to a preliminary hearing. The amended complaint is essentially a carbon copy of the earlier complaints with a long list of indiscriminate transactions that have no tie to an election. We argued this previously, that bank records don't provide information regarding whether a donation was received for the purpose of influencing an election. So it's not a surprise that the amended complaint doesn't differ from the earlier complaints in that way. I'm happy to answer any questions on the statute of limitations argument. Otherwise, I can move to the next.
What did this commission do with respect to Judge Walker's order in the Oxendine case?
Can you rephrase your question?
Yeah, after a decision comes from the Office of Administrative Hearings like that, it comes to this commission, for review, whether to accept it or overrule that motion from the Office of State Administrative Hearings. What did this commission do with that?
My understanding is that opinion continues to be good law. And so it's not my understanding that the commission set that opinion aside. Is that?
So we have a rule.
We did.
Okay.
I'm legitimately asking, I don't know the answer.
No,
Okay.
the Oxendine, the Walker opinion from Oxendine was rejected by this commission.
Okay. So even if the commission finds that the allegations in the amended complaint are not time barred, it is our position that the amended complaint does not provide specific facts, which if proven true, would support allegations that NGP and NGP Action Fund received contributions or made expenditures under Georgia law. I'd like to walk through the terms of of what the important terms and what they mean, and specifically the definitions under Georgia law, because they are important to understanding our argument. The first is campaign committee, an organization which accepts contributions or makes expenditures. So that is the action that must be taken in order for an organization to be treated as a campaign committee. The second is an independent committee. An independent committee must receive donations, and then it must expend such funds for the purpose of affecting the outcome of an election. Importantly, an independent committee does not necessarily receive contributions, but it does receive donations. So it receives money from the general public to support its purpose, and then it expends that money for the purpose of affecting an election. When are campaign committees and independent committees required to register and report? They are required to do so when they accept contributions or when they make expenditures. And what is a contribution under Georgia law? It's anything of value conveyed or transferred for the purpose of influencing an election. An expenditure is similarly defined. It is anything of value that is made for the purpose of influencing the nomination or election of any person. The amended complaint does not make any allegation that any of the transactions that are listed support a finding that they were made or received for the purpose of influencing an election. And that is important because it is the commission's burden to provide a reasonable basis and a reasonable belief that the specific deposits received or the specific outlays that were made were for the purpose of influencing an election. The date of a transaction alone is not sufficient to do that. The fact that a transaction took place during an election year does not provide a reasonable basis to believe. And I'd like to point commissioners to another handout that we gave. This is the CCDR report for Americans for Prosperity Action. And this report really shows what is meant in practice by the definition of contribution and expenditure, as I just explained. If you take a look at the page that discloses their itemized contributions, you see that they list one donor. And the donor that's listed is the same name as the committee that is registered. The reason for that is because they're taking the position that they did not receive money, donations, for the purpose of influencing an election. They're an independent committee. They receive donations. Certainly they receive donations from the public. None of them are disclosed on the CCDR.
Is your argument on this point that, again, the language of the amended complaint just wasn't sufficient, that it just didn't have an allegation in there that said that these monies were exchanged for the purposes of influencing an election? Is that what you're saying, that it needed to have that specific allegation in there?
It needed to have that allegation. It also needed to have facts to support that allegation with respect to the transactions that are listed. It's not enough to just list records from a bank account, allege that they're contributions and expenditures with no supporting facts to show that the transactions were made for the purpose of influencing an election. And what this report shows is that these terms under Georgia law mean something, right? It's not, you can receive donations from the public for general support and general purposes and not disclose them as contributions because they were not received for the purpose of influencing an election. And you see that that's exactly what has been done here. If you take a look at the next page of their itemized expenditures, you see that they disclose expenditures for printing and for postal service costs.
Hold on one second, Commissioner Thompson's got a question.
Yes.
So I understand you found a report that, goes with your argument. I mean, we could find a bunch of reports that are files that are completely different. I don't understand, are you saying that this American for Prosperity Action Inc., because they filed the way you guys think you should file, should be some kind of proof that they did it right? Or you did it right? Because this isn't a commission report, this is a report that's filed with the commission, but nobody at the commission that I know of has looked at it unless you know differently and said this is the way to do it.
Understood. What this report is intended to illustrate is that the definitions of contribution and expenditure are limited to money received and spent for the purpose of influencing an election.
Only if this report was done right.
Only if this report was done right, but they're not alone in reporting this way. And so this is how campaign committees and independent committees in Georgia report, because they're reporting in compliance with the law. I mean, this is really, it's a textual argument, right? A contribution is anything of value conveyed or transferred for the purpose of influencing the nomination for election or any election of a person for office. Same thing with expenditure. They have their terms of art, they have meaning under Georgia law, and this report indicates and shows that that's how other committees are reporting. That's how other committees are interpreting these terms. And they indicate that it is really important and that the staff has failed to meet their burden here because they haven't differentiated the transactions in the amended complaint to show that they were made for the purpose of influencing an election. That is their burden. Without that information, the transactions can't be contributions or expenditures by law. With respect to New Georgia Project, there are simply just no facts in the amended complaint to support any allegation that they received contributions or expenditures. Again, the complaint lists 2,000 transactions with no information about the purpose of those expenditures. When you look at the evidence with respect to New Georgia Project, and this is important because we've asked for the motion to dismiss to be granted with respect to New Georgia Project in its entirety, there's very, very little evidence in the amended complaint related to New Georgia Project. Every single exhibit to the complaint regards New Georgia Project Action Fund, with the exception of one social media post, which is a retweet of a New Georgia Project Action post, and with the exception of invoices from a design company which were addressed to NGP. Those invoices, as you can see here, are for door hangers, palm cards, rally signs. There's no indication that any of these documents that were produced by Best Print and Design were for the purpose of influencing an election. As we know, NGP engages in nonpartisan GOTV. It engages in nonpartisan voter registration. There's nothing in these invoices that indicates that these payments that were made to Best Print and Design constitute expenditures. Another important point is that if you look at the list of transactions in the amended complaint, there isn't a single one to Best Print and Design. So it's not clear that these invoices were even paid, and the commission staff didn't go through any effort to determine whether that was the case. Best Print and Design doesn't appear. It may be that this is getting too much into the facts if I go through examples related to other contributions that were, other donations that were received, but please let me know.
This was close.
if that's
You
the
know,
case.
by going into this, because this is actually presenting evidence outside of the complaint itself, but I went ahead and allowed you to go ahead and go into that. But yeah, if you're going into the examples, I think that's proper for the preliminary hearing.
Okay, and I'm happy to cover those then during the preliminary hearing, but suffice to say, the transactions in the complaint can be grouped into a couple different categories, none of which provide any information that they were for the purpose of influencing the election. In fact, the information that we have gathered from our clients indicates that they were not for that purpose. And so I will talk about those during the preliminary hearing.
I actually made a note specific to the 4 different categories that you raised in that motion, because I thought that was very factual. So I think that's proper for the preliminary hearing.
Understood. I'm happy to cover that then. I could go through, and I would like to go through just a couple of exhibits to the complaint, because it appears that commission staff are relying on the exhibits to the complaint to sort of complete the picture here, to provide the commission with facts that indicate that these organizations made contributions, received contributions or made expenditures. And it's just not proper. The amended complaint itself is really a recitation of law. It doesn't contain any factual allegations. The exhibits are wholly insufficient to meet the reasonable belief standard. And I'd like to talk through just a couple of the exhibits to show why that is. So this, for example, is an exhibit to the amended complaint. It's a Twitter post by New Georgia Project Action Fund that discusses that the Action Fund's director would be on the Chris Hayes show. And then it includes a hashtag Team Abrams. The first thing is that there are no costs associated with this Twitter post. Twitter's free, so there's no cost that would have needed to be reported. It's also focused on voter suppression. It's clearly not about electing a candidate. Ms. Ufat appeared on Chris Hayes and she talked about voter suppression being an act of desperation. That is within the primary purpose of the Action Fund. There's nothing about this Twitter post that indicates that money was spent or received for the purpose of influencing the election. Here's another one. This is a post that contains a donation link to New Georgia Project Action Fund. Certainly, New Georgia
Again,
Project.
I don't want to interrupt you, but again, whether there's evidence to show that there was, whether the complaint included the evidence, with regard to, influencing the election, I think that's what we're going to be talking about in the preliminary hearing, isn't it?
It is. I'm happy, I don't have to cover this here. I think the commissioners understand the argument, right? Is that there is no information, no facts provided in the amended complaint to support the allegation that money was raised or spent for the purpose of influencing an election.
And I've got that as your second argument there. And the only other argument that I have for you in the motion to dismiss was that they didn't state that there was a major purpose for
Correct.
Influencing elections.
Yes, and if I may cover that argument now. The amended complaint does not allege that NGP or the Action Fund have engaging in electoral activity as their major purpose.
And again, the only thing I want to make sure that I'm clear on here is that you're just saying that the amended complaint should have contained that allegation.
It should have contained that allegation, and as a substantive matter under the First Amendment, these organizations cannot be required to register and report as committees under Georgia law unless they have the major purpose.
And again, I think where you go there on the second argument is preliminary hearing material. I think the first argument, if you're saying that the complaint was inadequate because it did contain an allegation that their major purpose was influencing election, I think that's proper for the motion to dismiss. Agree or disagree?
I agree.
Okay.
And can I cover that just in some detail?
The first part, yes.
Yes. So, as stated, the amended complaint does not make the allegation that major purpose was, that the major purpose requirement was met. And the reason why that's important is because the Supreme Court has stated that political committees are subject to compelled disclosure, which can seriously infringe on association and belief guaranteed by the First Amendment. And thus, political committee registration and reporting requirements must survive exacting scrutiny. What that means in this context is that organizations like NGP and the Action Fund can only be required to register as committees where their major purpose is supporting or opposing the nomination or election of a candidate, or they are under the control of a candidate.
Is there law that says that a complaint in this context has to contain that allegation? Because I see that as the only issue at this point.
Without that allegation, the complaint does not, it does not properly make an allegation that the organizations were required to register as committees.
Okay, is there, and you have a law, you have a case, a statute, anything that says that that allegation is actually required to be in a complaint in this context?
I can look to see if there's anything that would specifically state that, but what I would note is that the major purpose test has been used to invalidate or narrow state laws that purport to regulate groups like my clients that lack a major purpose of influencing an election. So that's been the case in every single case that is cited here, from the 4th Circuit to the 10th Circuit to the District Court of South Carolina, and also the 8th Circuit. And as a result, state laws have been narrowed.
Do you have anything from the 11th Circuit or any of the district courts in the 11th Circuit?
The 11th Circuit has not directly addressed this matter. There is, however, a case in the Northern District of Florida which implicitly recognizes the existence of a major purpose requirement. That case is National Organization for Marriage versus Roberts. It has a site of 2011 Westlaw 131766734. In that case, the court stated that the major purpose requirement only applies when regulations are triggered by an organization's status as a political committee.
So the issue wasn't presented there, whether
Right.
such an allegation needs to be contained in a complaint in the context we're in here.
But it implicitly recognizes that unless an organization has that major purpose, it cannot have the status of a political committee unless it is under the control of a candidate. So, like I said, the 11th Circuit has not directly addressed it. There is this case in the Northern District of Florida. There is the Worley versus Florida Secretary of State case from the 11th Circuit, which I would argue also implicitly recognizes that state laws that define independent committees or political committees like we have here must have a major purpose requirement in order to comply with the First Amendment. The complaint does not allege that the C3 or the C4 have engaged in electoral political activity as their major purpose, and indeed they have not. As I said in the beginning, they're nonpartisan voter registration and voter engagement organizations. It would violate the First Amendment to apply the registration and reporting requirements to political committees that apply to political committees to entities like NGP and the Action Fund. I understand that, the commission is not a court. You're not here to declare Georgia law unconstitutional, and that's not what I'm asking. But I am asking that the commission view the law in a way that comports with the First Amendment, which I think is important in terms of upholding your constitutional duties as commissioners.
All right, any other legal argument with regard to any requirement that that major purpose be included in a complaint in this context?
I think I have covered it, and so I would ask that the commission vote to dismiss the complaint in its entirety, or that in the alternative, it vote to dismiss the complaint against NGP because there are no allegations made with respect to NGP, and that it vote to dismiss the complaint with respect to the Action Fund, with respect to everything except for the ballot measure activity.
Okay. Unless I get some major pushback from my fellow commissioners, because I know that we haven't taken a break, I would like to go ahead and get through this motion to dismiss before we break for any kind of lunch or anything. Does anybody have any problem with that?
Mr. Cusack is still punchy, but yeah.
My best.
Are you good, Mr. Cusack?
Should be.
All right, we're going to go ahead and get through the motion to dismiss then before we take a break.
Thank you.
Commissioners, I just want to make sure to try to frame the argument as best. The first thing you would like to hear about is the statute of limitations. Is that
Yeah, and here's what I want you to do, if you could. The first thing that I actually want to hear about is any difference that may exist between, as what I've been calling the project and the fund. Because we heard a lot about how they're sort of conflated into one organization in the, as far as how we flood it. So if we have a,
I think that's going to require factual.
okay, that's fair enough, that's fair enough. Then I want you to do statute of limitations. Then I want you to do, as far as the amended complaint goes, that there's no allegation in there that the two organizations were made for the purpose of influencing an election with regard to expenditures and contributions. And then the last thing, that the complaint did not contain an allegation that the organizations had a major purpose for influencing elections.
Okay, and so I'll start with the statute of limitations then.
May I ask, is there a copy of the PowerPoint that we could have?
Well, it's going to change, so I'm going to have to edit that.
That's going to be used later, or what?
Well, this is within.
Oh, I thought that he already did it.
No.
Oh, well, I'm sorry, I misunderstood then. I thought that you were,
He has the
Okay.
legal argument in the same PowerPoint.
okay.
Yes,
All
it's
right.
just later in the PowerPoint.
Well, then we're going to go ahead and need to take that break then, so that you can get that. I know, I'm sorry, but we need to do that, so you can get that done. Yeah, we're going to go ahead and take a break for lunch. Let's be back here at 12:45. We'll be adjourned until 12:45. Thank you. Back to order. I believe that we've got the commission staff ready to respond to the issues raised in the motion to dismiss. Mr. Cusack, you can proceed.
Yes, and I'll start with the statute of limitations argument. I think everyone's in agreement that this is not a elected official or a campaign for an elected office, and that the 3-year statute of limitation applies here. This is as many of you know, this is the statute of limitations as it currently stands. It changed from when this complaint was initiated, but I just listed the law for that. But the previous version says that when a complaint has been accepted by the commission in compliance with Code Section 2157, or the commission or attorney general serves on such purpose a notice of summons or hearing in accordance with the APA, then the complaint has been initiated. So just to go back to the dates of this complaint, it was filed on September 9th of 2019, and then amended on June 17th of 2022. And on that June 17th, 2022 amended complaint, there was nothing really new other than...
For personal privilege, I'm recovering from some eye surgery, so I really need it over here so I can see it.
It's updated.
Commissioner Burge, you can try to bring the microphone back over to you.
It's still not there.
Continue. Update again. Is that it?
Next one.
Next one?
Well,
Sorry. I don't have it. I don't have it, Joe.
here we are.
Can you see that?
Yes,
Okay.
sorry to interrupt.
No, it's totally okay, we need you to see it. So this complaint was filed on September 9th of 2019 and then amended on June 17th of 2022. And so this amended complaint relates back to the initial complaint, just further alleges with more specificity what the contributions and expenditures were that were made during that time. So the allegations of failure to register and failure to file reports was in both complaints. The allegations that respondents raised and expended money that was subject to reporting was in both complaints, and that was alleged with more specificity in the amended complaint. And then just to note, Commission staff received the bank records in March of 2022, and any statute of limitations runs from that time period when they received those records in regards to contributions and expenditures. We weren't on notice of that specific activity until that point.
Well,
The executive secretary has it.
yeah, Mr. Cusack, and correct me if I'm wrong, but hasn't the commission always taken the position that commission staff can commence their own complaints?
Yes, and that's always been the position of this commission, that argument that
So
commission staff.
that would toll the statute.
Yes, on September 9th of 2019, the statute was told.
All right. Go ahead.
So any delay in this case is due to New Georgia. They failed to turn over financial records in 2019 from the original motion to quash hearing in this matter. So any delay in this case has to be attributed to them. In regards, there was a motion to quash that was held before this commission in which they were ordered to turn over those financial documents and then did not. So in regards to that, we had to go and subpoena Wells Fargo to get those financial documents we were seeking. They then filed a motion to quash in Gwinnett County, lost that motion, appealed the ruling, filed the wrong appeal on that, and lost that appeal. And then after all that, they filed for a motion for relief of judgment in Gwinnett County and then subsequently lost that motion. So commission staff was finally able to receive those records in March of 2022. Now, New Georgia Project has cited the Oxendine decision in they have cited the Oxendine decision in their reading of the statute of limitations, and this commission has rejected that decision and interpreted the statute of limitations as relating back to that initial complaint, which would have been September 9th, 2019. And also, those cases are dissimilar in this matter as well. And I wanted to move on in the argument. I don't know if anyone has any questions about the statute of limitations, but
Joe, hold up.
Hold up.
We've got to catch up.
I was going to move on to the amended complaint, and that New Georgia was on sufficient notice of what was being alleged in that case.
Now you're not up over there. If you need to take 2 minutes to get with Erwin to figure out where.
What feature are you going to on?
It's 56.
I'm not just listening.
No, I believe you.
I think I'm gonna say it.
So make sure that we can only get the redacted.
The one on the left's not redacted, so we pull that down.
This is not redacted.
Can you just put it on this one? Can we put the main one on this one?
How about this?
I can see that better than that.
Yeah, we can see that better.
So I'll move on to the major purpose test and then come back to the complaint, not putting them on notice of what actually is being charged, if the commission does not mind.
Okay. The only issue with regard to the major purpose test, as I understand it, is that the amended complaint did not specifically allege that a major purpose of the two organizations was influencing elections.
And just to give a quick rundown of the major purpose test, that is not required. The major purpose test has a circuit split. It is only applied in the 4th Circuit, the 8th Circuit, and the 10th Circuit. Those are the only circuits that apply the major purpose test to state campaign finance laws. And the rest of the circuits differ in their application and do not use the major purpose test. So the 11th Circuit actually applies exacting or strict scrutiny to campaign finance laws. So our disclosure law is narrowly tailored to achieve the government interest of finding out who is funding express advocacy communications. And I'm going to get into the 11th Circuit case that is Ritchie v. Tyson, which actually held, and that's Ritchie v. Tyson 120F supplement, or SUPP 2D1298, in which Ritchie held, for the purposes of the First Amendment, an organization may be subjected to constitutionally permissible election finance restrictions, even though its major purpose is not to engage in campaign activity. So that means that even if there isn't a major purpose for that organization in political activity, they can still be subjected to state disclosures and triggering registration with state regulation entities. And that case further says, for organizations whose major purpose lies elsewhere, the legislature may require disclosure only of those expenditures used for express advocacy. And that's the standard we use at this commission of express advocacy triggers registration. Thus, the major purpose distinction influences the degree to which an organization may be subject to election finance regulations. It does not determine whether an organization is constitutionally immune from such regulation.
Yeah, and I remember that this actually came up during the motion to quash hearing, and boy, I'm reluctant to do this, but I'm going back to Commissioner Watts again, and Commissioner Watts actually made this argument before, and that's that, you know, a number of things can happen with regard to an organization. The organization can claim that it does not have, you know, a purpose of influencing elections, but what are you supposed to do then when it changes course and perhaps, number one, doesn't tell the truth in that regard, or number two, changes course and starts, you know, activities that influence the elections? Is that just a situation then where they just go unpoliced? And so what I'm reading here from the 11th Circuit, at least, or a case from the 11th Circuit, is that if you have that situation, even where you have you have an organization that has a mixed course, where it has influences on elections and maybe other business influences, that you're still subject to campaign finance laws. Am I understanding that right?
That's correct, yes. And if you look at how our laws, or how an independent committee would be triggered to register, it's that objective of express advocacy communication, which would trigger registration. So it's an objective standard here. And Ritchie cites Massachusetts Citizens, and it basically says that none of the major purpose test holds, and few even remotely suggest that an organization whose major purpose is not the achievement of particular election results is constitutionally immune from regulation. So we're basically saying the major purpose test doesn't matter. If you do X, Y, and Z in terms of our campaign finance laws, if you expressly advocate, you accept contributions, make expenditures, you're subject to regulation.
And I'm not going to make this any longer, but even with any of the jurisdictions that you cited, the 4th Circuit, the 10th Circuit, and whatnot, do any of the cases from those circuits, do they impose a requirement, you know, in a proceeding such as this, that your complaint actually contain a specific allegation that says that an organization's that an organization's purpose has to be to influence an election?
No. It's only that, I guess the definition, it's defense that is raised that somebody would not be subject to regulation because they fail, or their major purpose isn't election activity. And then, commissioners, I'll go ahead and just cite from the complaint. I want to hit on something that Ms. Branch brought up in terms of best print. Basically said that the contributions and expenditures in this matter were just thrown into this complaint. They're on sufficient notice of what the violations are and what the violations are, what they're being charged with, and then we use evidence to back that up that they were subject to regulation. Now, here, she made mention and cited these invoices. Well, what were these invoices related to, and why didn't she show you that? So it's door hangers, palm cards, door hangers again, and door hangers again. So to go back, this is what that was related to. This was that expenditure that was made in terms of the express advocacy. So vote for Stacey Abrams, vote for Sarah Riggs and Nico. So they just want to say that, oh, these invoices mean nothing. Well, these invoices were for express advocacy communications, trigger registration.
Commissioner Watts.
How do you know, I was having a hard time following, so with the screen, how do you know that invoice was tied to that?
This was sent in response to a subpoena sent by the commission.
Well, it actually says at the bottom, paid for by.
Yes, and it says paid for by New Georgia Action Fund.
Okay, I just can't see it.
That's at the bottom left.
Yes, that's at the bottom of both of those sides of this, what would be door knocker, palm card, what have you.
Okay.
So everything that's in the complaint builds on each other. It's evidence that there was express advocacy, that they had to register because of that, and they're on sufficient notice of what the violations of law are. Viewing those facts in the light most favorable to us, they're on notice of what they're being charged with, of what is alleged that is violations. So I think that argument that these contributions or expenditures weren't made is totally false.
Well, this is a motion to dismiss, but are they saying none of these were, is that their defense, that this was not paid for by them? Because it says so at the bottom.
Yes, that is one of the defenses.
Well, that kind of gets into the C3, C4 to be fair to Ms. Branch and her client, that kind of gets into the C3, C4 distinction, and that gets a little more factual.
Okay.
I mean, I think at this point, Mr. Cusack's point is, we've alleged a violation of the law, we've stated it, that facially meets the notice requirement.
That's fair.
Go ahead.
And is there anything else that I needed to address? I might have forgot some things.
I think the other issue, if you just address this, that's fine, but again, there was an argument made that there needed to be a specific allegation of, I guess, which I guess is what you just addressed about influencing the elections, that you didn't have to specifically state the contributions and the expenditures, right?
Correct,
In the-
correct.
okay.
Yes.
Yeah. All right. I know that was, anyway. Is there any other questions for Mr. Cusack with regard to any of those three issues?
I have one question.
Go ahead.
I think there may be an issue later whether New Georgia Project, the C3,
I'll have some
Then-
evidence on that during my
that
presentation.
may be a factual question, but my understanding is we assume your complaint is true for purposes of what we're doing right now, and that everything in there is as given. Did you allege, and I also realized most of the exhibits you attached, including that one, referred to the Action Fund. I just wanted you to point to me what you allege that the foundation, that the Action Fund, not the Action Fund, the New Georgia Project did that was a violation.
So that's
Or
actually,
do we need to wait till either this afternoon or the full hearing to address that?
Yes, we would. We will be presenting evidence that New Georgia Project was paying for canvassers and other expenditures out of the New Georgia Project account. And that also the New Georgia Project Action Fund account was doing the same thing, or paying for express advocacy communications.
But
But to his point, did you allege that?
It's alleged. I don't know if Mr. Motter.
I think the point of the complaint is they're both alleged to have violated the law. And the factual argument we're going to make is that it's effectively intertwined as one entity.
I understand that, but I mean, you made.
We allege both
Yes, both have been
entities.
alleged.
Yeah.
Yes,
Yeah.
both entities.
I guess the only other thing that the only other comment that I want to make with regard to the sufficiency of the complaint is that, I think we're still in a state that, only requires, notice pleadings. And, I felt like I made it a point at the beginning of the meeting today to run through all the allegations, of the complaint, what I had termed to be primary allegations, and then what I had termed to be more specific allegations. And I believe that everyone was in agreement with regard to what each of those were. And so, I don't see where there was any confusion at all as to what the allegations of the complaint or the amended complaint were. So, with that in mind, and with regard to the statute of limitations, again, I think that the issue has been answered by the commission. I think that there was reliance in this case on the opinion from OSA in the Oxendine case, which this commission rejected when it came to us. So in light of all that, I'm going to go ahead and make a motion that New Georgia Projects and New Georgia Projects Action Fund's motion to dismiss in this case be denied. Do I have a second?
Second.
I got a motion and a second. Do I have any discussion? Hearing no discussion, I will call the question. All in favor say aye. Aye. Any opposed? Motion carries. All right, so we have dispensed with the motion to dismiss. We are now going to go ahead and proceed into the preliminary hearing. Mr. Cusack, you're going to go first with regard to the preliminary hearing. Now, in the preliminary hearing, we have narrowed the issues, I believe, to 2 questions. And I believe that the 2 questions here are these entities an independent committee, and are the entities a ballot committee? So go ahead and make your argument. Yes.
Before we do that, Mr. Cusack, earlier we saw that the redactions occurred in this PowerPoint, but I don't believe the redactions had occurred in the alternate PowerPoint. And I think the commission has indicated.
They're in the alternative PowerPoint too.
Okay?
Yes, Mr.
Yes, yes.
Okay, all right.
Okay.
I just wanted to make a point that if they're only in one, I think they would prefer it be on that board rather than the other.
Yeah.
But if they're in both, then we're good.
They're in both. So this case is 2019-0050. This is a matter of New Georgia Project. I went through the background of this complaint. The complaint was initiated by the commission on September 9th, 2019. And it alleges those 2 issues that Mr. Chair laid out of that New Georgia Project failed to register as an independent committee in 2018 and in early 2019. And there was a subpoena issued the same day for various records relating to activity that was done for electioneering activity. Here's the subpoena that was issued. I believe we had a hearing on this, the commission did, and ultimately New Georgia Project filed a motion to quash on that subpoena, which was heard on December 4th of 2019. That motion to quash was denied by the commission. The respondent, New Georgia Project in this case, partially complied with that subpoena.
I'm sorry.
So, let me just say this. So we've been through a lot of this. I think it comes down to the 2 questions.
Okay,
I don't
and I can
know
go ahead.
that we need to do this historical kind of, 4-hour thing again. I mean, I think our first decision is, do we believe that they should register as an IE? And the answer is yes or no, right, based on the evidence. And that would be, that would take care of the first violation. And then we have just go straight to the evidence that you have or don't have, on whether or not they should have been a ballot measure committee, then they can respond to those two questions. If we need more historic, again, this is a preliminary hearing.
No, and again, I'll speed it up. I can't agree more.
I'm not saying speed it up.
No, I'll get to that issue. Okay.
We're just trying, that was my point this morning.
Trying not to bore everyone.
Well, you're not boring.
Oh,
Don't put it that
I'm
way.
not bored.
Yeah, that's not the issue. It's just that we've tried to narrow the scope of this, and if we can get it down to those two points,
Okay.
that's fine. And again, I know that Ms. Branch has some legal issues to address within that, and that's fine. But again, let's keep it to whether these were, should have been considered independent committees or ballot committees on that.
All right, so here is one of the first pieces of evidence that you've already seen me mention, where this is a door knocker, palm card, what have you, that was made by Best Print, and it says paid for by New Georgia Project Action Fund. It says vote for, and it's interesting too because this says vote for all these candidates on this communication, and then it says this November you can vote for a slate of leaders who care about the issues that are important to you. Now here is the invoices that Best Print sent to New Georgia Project for those. And then also here are door knockers that are different from the one I just showed you. And those again at the bottom say paid for by New Georgia Project Action Fund. And then on the other picture you have canvassers on September 27th of 2018 with those door knockers right there. So right away you have the express advocacy test met, and then the expenditures being made obviously to pay for these. Now right here we have another picture with that I guess door knocker, if you will, with canvassers, and it says kicking off canvassing at our new office in Norcross. So the canvassing, there's a couple things that have to be paid for here under expenditures. The door knockers, the canvassers, and the the headquarters that they're operating out. And so that was in October of 2018. There's another on October 12th, 2018, every Saturday at our Riverdale office. You know, if you're mad, come canvass with us. So that was on October 12th, 2018. So you see, and you can't get a great picture of what's in there, but that's what another one of those door knockers.
Excuse me, Commissioner Watts?
Is there any dispute whether the money was, or how the money was spent? Like, is there a factual dispute between the money, how you're alleging the money was spent here? Or are we going to have a legal argument here shortly about whether, regardless of how the money was spent, they could be an independent committee?
There is a factual dispute.
Okay, all right, just.
So here's the same thing. You see on September 28th, there's the South Metro canvas team is fired up to win. And then it says New Georgia Project Action Fund is hiring paid canvassers in Atlanta, Georgia for $15 an hour. And then here are all the canvassing offices, and these would be subject to reporting requirements on the rent or the space rental for those. So you have Norcross, Tucker, Riverdale, Augusta, Macon, Columbus, Dawson, and Albany. And then you have the canvasser script from New Georgia Project Action Fund, and this was for the general election, in which it says, "Hi, I'm a canvasser with the New Georgia Project Action Fund. We are in the community today talking to voters about the 2018 Georgia general elections." It says, "That's why I'm supporting Stacey Abrams. Can we count on your vote for Stacey Abrams for governor of Georgia by November 6th?" So you have that express advocacy script. And this one was just another one as well. Here we had on September 24th, New Georgia Project tweeting out that they are meeting with Working Families Party on Saturday, September 29th, 11 to 5, and what's at the Riverdale office. So I think these dates are going to end up being important, so that's why I'm bringing that up. And then here's for the primary, where it says, "Hi, I'm a canvasser with the New Georgia Project Action Fund. We are in the community today talking to voters about the 2018 primary election for governor." It says, "Can we count on your vote for Stacey Abrams by May 22nd?" So we have another express advocacy script during the primary. Now, during that time, the contributions accepted was about 4.2 million. There was 117 separate contributions. And then there's actually more than that because a lot of them were with ActBlue, so it goes in as just an ActBlue contribution. But here is the money entering the account with the redactions.
What do you mean by more than one from ActBlue?
So with ActBlue, some of those would go in on, say you have a date and it says ActBlue Civics and it's $6,000. That could be any sort of time period leading up to whatever that date was. So it could be multiple contributors bundled into that, how it enters the account. So there's more than likely going to be more than 117 of the separate contributions or the contributors here. So the expenditures made was about 3.2 million made from 5/31 of 2017 until 12/31 of 2018. And there was over 1,800 expenditures made during this time period per their records. Now, in regards to some of these,
Since there's an apparent factual dispute on how the money was spent on campaign activities, can you tell me show me exactly what you've got for how you're connecting the money to the campaign activity that will qualify as an independent committee?
one second.
You're fine.
So here is,
Hold on.
Hold on.
Is that it?
Shut that off, shut that off.
Yeah, turn the one on the left off.
Yeah, hold on.
Oh, I keep looking. I'm good.
I'm still finding. We'll take a second.
sorry, everyone's trying to keep up and I'm bouncing all over the place. So here it is on 9/20 and 9/21, purchase authorized from Best Print and Design. This was from the Action Fund bank account. During this time period, during this whole activity during the general cycle, Best Print was paid about $36,824.75. I spoke to them, and it's important to know that they just gave us what they had. They didn't have everything, but they were able to turn over that Express Advocacy flyer and the subsequent invoices that came with it. And as we saw from the pictures I mentioned before, that there was more, there were different ones that were actually made. So this is from the New Georgia Action Fund bank account where they're paying Best Print during that time period and during this election.
And Best Print gave you the flyers?
Yes. And just to, that is something that wasn't turned over by New Georgia Product. So that was, we had to go and get that after examining the bank records.
And is that flyer in the presentation? Is it one of the ones you showed us already?
Yes, it's the first one I showed you. I can go back to it.
Got it, okay. I've got to ask this question, excuse that, because I'm sitting here, again, you're making an argument now as to why they were independent committees, right?
Yes,
Right, so I think we've got to start with the definition, right?
correct.
So I look at the definition of independent committee, it says, any committee, club, association, partnership, corporation, labor union, or other group of persons other than a campaign committee, political party, or political action committee, which receives donations during a calendar year from persons who are members or supporters of the committee, and which expend such funds either for the purpose of affecting the outcome of an election for an elected office or to advocate the election or defeat any particular candidate. Right, so I want you to tell us why that activity meets this definition and establish why that's an independent committee.
Yes, so looking at this, you also have to take into account the express advocacy portion of that. So if they're making expenditures that are vote for, vote against, then they are subject to registration. They're subject to registration and reporting. So here, using that test, they have, with this, just this communication right there triggered that, by saying vote for Stacey Abrams for governor, vote for Sarah Rizzulico for lieutenant governor. This November, you can vote for a slate of leaders that are on here.
And you're on this one now?
Yes.
Because that's not what's, okay, now it's over there. Okay. Here's the other question that I have, and I'm sorry to. Are you alleging that these organizations were campaign committees and independent committees at the same time?
Just saying they're an independent committee.
Are you alleging that they're independent committees and campaign committees at the same time?
I think we just allege that they're an independent committee.
Well,
And the,
Mr. Cusack, I'm looking at the definition of independent committee, okay? Independent committee, the definition includes a committee, club, association, partnership, corporation, labor union, or other group of persons other than a campaign committee. So I don't think you can be a campaign committee and an independent committee at the same time.
correct.
That's why I'm asking the question, because I know that the complaint here has allegations that they are a ballot committee, which is a sub-definition of campaign committee. I want to know how we're addressing that.
That is a separate election with separate evidence.
Okay, that's
Yes.
what I wanted you to
Okay.
establish. We're not actually, or you aren't actually alleging that they were a campaign committee / ballot committee at the same time that they're an independent committee. It's a different election.
Correct, yeah, that is a whole, that is a different election and a different set of evidence that pertains to that.
Go ahead.
I have a question.
Oh, sorry.
Um, So you indicated earlier that the law states that for them, well, let me see if I can, how do I say this? The defense is stating that it's not their primary purpose. You're saying that it's irrelevant about the primary purpose if you do it. Is it one time, 2 times, or it doesn't matter? If you do something that indicates that you're campaigning, it's irrelevant.
It is, yes.
Okay.
Yes, and it's because we have that express advocacy standard. The moment you use one of those communications, that's when it triggers your registration.
Okay, so it's not 10% of the time, it's if you do it.
If you do it, it's an objective standard. Let me get back to. So I believe I was on the expenditures that were made. Here are the expenditures that are made during that time. So we start to see a lot of activity for the expenditures that were made. A lot of this is for canvassing. We'll get into where there's, if you can see on the right side, and I don't know if you can make it out all, but there's gift cards. We have been given information that the gift cards were used for like reloadable gas for the canvassers. So you have all these transportation expenses for canvassers, the canvassing headquarters, the rent for them. There's going to be vans that are rented in here, and then the individual canvassers themselves are being paid out of the actually what is the Inc. Bank account.
But Mr. Dawson, but the canvasser, what is that? I mean, they're canvassers. We already know part of the point of these organizations were to get out the vote. There's several different things you actually have in here where it just says get out the vote, which would fall precisely into a C3 or C4 activity, right? So just because you're seeing canvassers there, how are you drawing that conclusion that it was for independent expenditures and not just to get out the vote, which would be permissible?
So you have those pictures I showed you. Also, you have the scripts, the express advocacy scripts that were used, and then you have the canvassers, the pictures of the canvassers with that, or the independent expenditure with the door knockers, palm cards, etc.
That's a big assumption that those canvassers were having those gift cards.
Well, I'm just setting the stage for what a lot of this is. So. But even using New Georgia's response, they said there was transportation costs, canvasser costs, the offices that those were run out of. So you have all those things, it's admitted by them that is what some of this money went for. It ties into their vendor argument. Now, here is where some of these canvassers were being paid, and this is actually paid for out of New Georgia Project, the Inc., on these checks, and you see the hours. There's a second one.
And if I may just interrupt, not to be rude, but I do want to note for the record that we've not seen these checks, and I cannot see them. They're really small, even on the copy of the PowerPoint that we have.
Whose bank accounts is it?
New Georgia Project.
Do you not have access to that bank account as their legal counsel?
We do, to the records, but we have not seen these as evidence that the commission is relying on.
And I hear you as far as not being large right there on the screen, but if any of you want to move over to one of those chairs down there on the end, by all means, go right ahead.
Thank you.
And then I just pulled some of these out. There's hundreds, but you see this one on the right. It was from 1/25 of 2019, and it says Arturo Palat, parentheses, canvasser. And then you see Mr. Palat, he was paid $1,200 in 5/25 of 2018.
Before we leave that issue though, where did you obtain these?
This is through the subpoena to Wells Fargo.
Is this the one that came out of Gwinnett County?
Yes,
Okay.
yes. So that's how we got all these records.
Okay.
They had the statements, the checks, and the statement activity for these time periods.
Okay.
And just to go back, so these were other canvassers that had how many hours they were canvassing there. And then
The canvassing was for a specific candidate and not just get out the vote.
well, if you look at, so you saw those Instagram posts where they had those, I guess the door knockers or the palm cards, right?
Yeah.
So those are for just a slate of candidates, if you will, multiple candidates.
Sure, but like that, you know that canvassing for whatever's being paid for right there was connected to the voting for those 7 people?
From those pictures, or?
I'm asking how do you connect that? Like what's to Commissioner Thompson's point, there's get out the vote and then there's advocacy for a specific, initiative or candidate. So how are we connecting that money that's on the screen to the one that you're alleging is a violation of the Campaign Finance Act?
Well, they're saying, so from that this vendor, and this more ties into the vendor argument, and I don't know if maybe we want to wait to get there, but the vendor argument, those canvassers were paid for an express advocacy canvass, and it was $100,000 during the primary and then $500,000 during the general. Okay, so they had to be paid. We know that pot of money went for an express advocacy canvass, and so those fall into those time periods.
Mr. Ryan?
I don't want to jump ahead of Mr. Cusack, because I know he does have evidence he wants to talk about outside of the scope of those vendor contracts. But I think the point is, we are alleging they were an independent committee. It's a yes or no question to Commissioner Thompson's point. But if they were an independent committee, as we allege, they would have had to disclose all of their activity, which is why all of that activity is listed in the complaint as having been failed to have been disclosed.
All their activity from which organization?
Well, again, I don't want to jump ahead of Mr. Cusack, because I think he does have evidence that shows the two are intertwined. But the point being, at this stage of the process, to Commissioner Burge's point, yeah, it is impossible to pinpoint one to the other without taking witnesses from the organization, deposing them, asking what activity was when. I know he also has a witness we've spoken to that will also shine light on that. But I think the underlying point is, if you agree that they're an independent committee and they have expenditures from that account that need to be disclosed, all of it needed to be disclosed, which is why they're all alleged in the complaint at this point.
But are there dates that match up that we know that there was I'm using canvassing as an example again, but canvassing going on for specific candidates?
So it's tough to nail down those dates. We know it's going on during that time period, like say September 27th. We have that, they're not going to get paid until 2 weeks later. So we see this sort of continual activity of canvassing going on, but in terms of specific ones, we can't narrow that down yet. We can meet the probable cause standard of, it's an independent committee, they're subject to registration, but the next round, whenever we get to OSA, would be take depositions on this and further try to narrow down exactly how much that was.
Mr. Kuzak, can you talk about canvassing, can you talk about the vendor argument they're gonna raise, the time period of the vendor argument, and then canvassing or other facts that negate that vendor argument? Because I think that's what a lot of this is driving back towards.
Okay, so this is the vendor argument that they've raised. The argument applies for the 2018 cycle. The Power Pack contract in the primary was from May 14th to May 29th, and the total expenditures during that time period is $142,031.79. The Power Pack contract in the general was from October 8th to December 31st, and that final report was due on November 13th. And the total expenditures from that time was $2.18 million. And then the general runoff contract period went from November 27th to December 31st. Now here's the contract from the initial primary express advocacy. Now in the response to the complaint, New Georgia has somehow said that this contract, with a conclusory statement, says it runs from May until October 8th. Even though the plain language of this contract says it's for the program to contact black voters to vote for Stacey Abrams during the May 28th gubernatorial primary election. So any plain reading of that contract says it's for the primary election.
What do you say that, I don't mean to put words in your mouth, but what do they allege that?
They allege that it goes from May 14th up until October 8th.
But for what purpose?
Well, remember when I said that there was that canvassing was going on September 27th? They're trying to encompass that in there to escape liability here, even though all of those expenditures say paid for by New Georgia Project.
If they're paying for canvassers outside the scope of the contract, they're not a vendor.
So that would be correct. We're saying they're outside, they are not a vendor, it's outside this contract, and that triggered the registration there, and they should have been reporting as an independent committee. Now here's the October 8th contract, and this was for the express advocacy there. Now, all those contracts say it's for the express advocacy for Stacey Abrams. So we're saying this is outside the contract, outside of the time period, but also there's nothing in that contract that says they could have advocated for these other candidates that are listed on this communication. So this would be an express advocacy for Sarah Riggs Amico, Otha Thornton, Richard Keeley, Lucy McBath, Jen Durden, Sam Park, and Matt Wilson as well. And you can see from there it says paid for by New Georgia Project Action Fund. So also, to go back to one of the Instagram posts I mentioned, there was also another one of these in which Lucy McBath was not one of the candidates on there. So there was other communications as well prior to that contracted time period.
So have you found any palm card or door hanger that has a paid for by the other organization that they were the vendor for?
No. It all says for it. And you can look at the Express Advocacy canvas as well. It says paid for by New Georgia Project Action.
Yeah, that's why I'm confused. It says that on there. It is Express Advocacy. I don't know what we're still doing.
Well,
I'm just saying, it's not listening to why it's on there. Because it is an independent committee if it's Express Advocacy, unless they're able to tell us a reason it's not an independent committee or it's not Express Advocacy. And, you know.
I think, and again, I'm not trying to jump the shark on Mr. Cusack, But I know part of what he's going to point out is that the May primary contract from May 14th to May 29th, where the respondent is arguing they were a vendor, in that contract, Mr. Cusack, correct me if I'm wrong, but that contract stipulates that the New Georgia project is to pass out canvassing materials that say paid for by Power Pack, correct?
Yes, that's correct. It says materials given to them by Power Pack or Canvas, and I have a so managed distribution of any canvas materials provided by Power Pack Georgia.
And we don't have materials that were distributed, that were said paid for by Power Pack.
No, we do not.
And do you have any information about those materials, whether they may or may not have existed at the time? I'm just trying to cut through, get what Mr. Commissioner Thompson's asking about.
And is Power Pack registered?
Yes, Power Pack is registered. So from those Power Pack,
Let Mr. Yap catch up.
but also we had, just a quick aside, this is an email chain from the director of Power Pack to Nsé Ufot, who is the executive director of New Georgia Project. And he's basically explaining that the scripts have to say, I'm a canvasser with Power Pack Georgia, and then close with the disclaimer, this effort is paid for by Power Pack Georgia. And then he says that they can wear their NGPAF t-shirt, but it's critical that they identify themselves as canvassing for Power Pack Georgia. And then we see from the Express Advocacy scripts that it says, I'm a canvasser with New Georgia Project. And that's what these next two scripts say. But in regards to these canvas materials provided by Power Pack Georgia, we received an affidavit last week from the former office manager from New Georgia Project, Ms. Stacy Hopkins, in regards to the I guess what the door knockers or express advocacy materials that Power Pack was supposed to send to New Georgia Project. She was able to state that those materials were never used, and in fact just thrown away, and just never used by New Georgia Project at all, that they used their own express advocacy materials. And then here's a text message between Ms. Ufot and Power Pack, in which she states that Stacy Hopkins is the office manager and she'll be there to receive packages.
Is that an affidavit in
Should be.
Oh, it's at the end? Okay. Go ahead.
And then I pretty much finished up my presentation in regards to the independent committee. I don't know if the commission wants me to move on to the ballot committee.
Yes. And the ballot committee only deals with the 2019 election in Gwinnett County?
Yes, that's correct.
Okay.
Just quickly, it was a question on whether to execute a contract for MARTA in Gwinnett, and the election day was on March 19th of 2019.
I gotta say, tell me what the rule was with regard to the 15 days.
So 15 days prior to the election, you were required to file a campaign contribution disclosure report.
Because I saw something about March 14th, that it was actually March 4th, right?
I believe so, it'd be a scrivener's error then.
All right.
But here is the vote yes, or one of the vote yes communications here. This is from Mr. Fred Hicks. He was the campaign manager for New Georgia Project Action Fund for this MARTA referendum. So in this Twitter post here, you see the signs that says vote yes to transit today. I'll get in, there's a better picture I have of those signs, but I'll show that to you in a minute. But there was texting that was done here. You can see in this picture, this is would be at the Norcross location in Gwinnett County. So that's where the canvassing was done out of. On this picture, you see the vote yes to bring MARTA, and that was to Gwinnett. Here is a call script from New Georgia Project for the MARTA referendum, saying, I am calling about today's vote for the Gwinnett County Transit Plan. Every voter in Gwinnett has the chance to vote today on expanding our transit options, reducing congestion, and connecting us to the region. Can I count on you to vote yes on the transit referendum today? And then they have a different script for during the week. And then here at the bottom, you say they have a disclaimer on what New Georgia Project is in case anyone asks on the phone. Some more activity. This says vote yes to transit, that same sign. You see the canvasser that's saying canvassers in the street hustling out the vote in the office. This day of action is on and popping. Gwinnett, are y'all ready to vote? Election day is March 19th. Here's the website that New Georgia Project Action Fund started for this. It was Gwinnett on the Go. And there was, this ad is actually called 3 Reasons. It was 3 reasons to vote yes. So you see a yes vote is a yes for transit, transportation for just 1 penny. A yes vote is a yes for less. And then there's also a donation link there to donate for this activity. Here's some more of the same signs. There's a watch party on election night, Tavern at Medlock, which said free food and open bar. All those things would have cost money. Then they have texting output here. Here's more of the signs. And then here's a better picture of the sign, and you can see in the bottom right corner, it says the New Georgia Project Action Fund. It's got the logo on those sides.
That's in the bottom right corner of that?
Yes. And here's another Express Advocacy handout. There was an AJC article that dealt with this ballot referendum. I was talking about New Georgia Project's activity during this time. And I'll get to that in a minute, but here's the flyer, the 3 reasons to vote yes to MARTA and from MARTA to Gwinnett. So this is quoted Mr. Hicks, and it says, what's very clear to me, Fred Hicks, the New Georgia Project Action Fund's campaign manager, is this whole thing hinges on who comes out to vote. Hicks said the group has paid canvassers like Sanchez, who is mentioned in that article, that's actually her in that picture, wandering Gwinnett since before the Super Bowl. So before Atlanta had the Super Bowl that year, if y'all remember that, but before the Super Bowl that year, they were paying canvassers and admitting this right here, and that they say they hope to hit 100,000 doors by election day. And also highlighted right there, there's talks about the texting efforts led by New Georgia Project. And then here's a script for the canvassers for the MARTA referendum. It says, hi, my name is blank. I'm with the New Georgia Project Action Fund, asking you to vote yes to bring MARTA here to Gwinnett. So it's an Express Advocacy script. And then this HEG LLC was Fred Hicks' company, and these are some of the invoices. He didn't have all of his invoices from that, but he had some of his invoices left over from that. He had a computer crash and was only able to recover some of the documents, but these are some of his invoices from that MARTA referendum. This was another Express Advocacy communication. And this is actually Mr. Hicks' evaluation group being paid for out of the New Georgia Project and not the Action Fund. So it's New Georgia Project, Inc. Is paying him for this election work.
Are they separate bank accounts?
New Georgia Project, Inc. and the Action Fund?
Yeah.
Yes. So with PowerPack's money was deposited in the Action Fund bank account, but you see canvassers being paid for out of the Inc. You see Mr. Hicks's activity here for the ballot committee being paid for out of the Inc. So it goes between both bank accounts on the political activity. And so you see here that New Georgia Project, Inc. is actually paying for the campaign manager for the ballot committee.
The video.
And then here is canvassers for during that time. They're being paid for out of the New Georgia Project, Inc. Here are some more checks or expenditures, what we're alleging would be that time. I do have a video of what would happen And this is a video of what would happen when you saw that donate sign there. This is what would happen. It was the New Georgia Project Action Fund, but this is what would happen when you clicked donate. So right there, when you're supposedly donating to the C4, it actually brings you back to donate to the C3. So, and you don't see any ActBlue or any contributions really entering the New Georgia Project Action Fund. You see it entering the New Georgia Project Inc. So this, on the Action Fund, whenever you went to donate to the Action Fund, it was actually bringing you back to donate to the C3. So we're saying there's no daylight between these two. There's political activity happening in the C3, there's political activity happening in the C4.
So let me ask this. So I understand that this is for the ballot one, but going back to the independent expenditure, do you have a same type of, because as you stated earlier, these are for two different elections, so one's an independent committee one. Why is New Georgia Project tied to the independent expenditure? I understand why they're both tied to this one, but why are the election issue?
New Georgia Project Action Fund, the money from Power Pack goes into that bank account. The canvassers are paid out of the New Georgia Project Inc. bank account. So it doesn't appear that any canvassers were paid for out of the Action Fund bank account.
Let me ask a question, Mr. Cusack. Did the Action Fund post fundraising links during the 2018 election? Because I'm trying to get at Commissioner Thompson's question.
All right, so we talked about some fundraising communications. So we have these two that were from the New Georgia Project Action Fund's Twitter account. It says, whatever lies Brian Kemp tells tonight, we are going to keep scaling up when hashtag Georgia poll, hashtag debate, hashtag Georgia governor debate, hashtag Georgia politics, hashtag Georgia gov. And then if you look in there, there's a donation link to keep the field team growing through ActBlue. And if you look at the second one as well, it says Brian Kemp can't stop lying about us. We know it's because he's afraid of the work we do. Donate here to make sure we get the truth out to Georgia voters. Hashtag Team Abrams, hashtag Georgia poll, hashtag Georgia Gov, hashtag Georgia politics. Now, you cannot say that this communication right here is not for any donation raised from this is not for a political purpose. So they are fundraising, and these are obviously for political purposes here. So that's just to show that.
Now, the second part of my question, though, which is what Commissioner Thompson was asking, these are ActBlue donations linked and hosted by the Action Fund.
Yes.
Do the Action Fund's bank account have ActBlue donations in it?
It was only the Inc., only New Georgia Project Inc.
Let me make a question. So in the amended complaint, all those contributions from ActBlue, those were into the New Georgia Fund, the New Georgia Project account?
Yes.
Okay.
That, I've jumped around a bunch. Unless you have any other questions, I think I've sufficiently. I have some case law, but we talked about the major purpose test, so I don't know if we need to cover the statute of limitations again or.
Nothing about that.
No. Okay.
So with that, if there's any other questions, I'm happy to take a seat now.
Okay. Ms. Branch? Again, you can remain seated or you can get up. It's fine with us either way.
I do have a couple slides I'd like to
Okay.
reference.
Are you also going to start with the independent committee and then go pilot committee second?
Yes.
Okay.
If I may, and I'm going to keep it very brief. All right, I'm just trying to figure out. I want to address 2 points that were made in Mr. Cusack's argument opposing our motion to dismiss, just because we didn't get the opportunity to respond to those. One, on a major purpose test, I believe Mr. Cusack stated that the Ritchie v. Tyson case was from the 11th Circuit. It was not decided by the 11th Circuit. It is actually a Southern District of Alabama case that was never appealed. The 11th Circuit has not spoken on major purpose. As I stated earlier, there is a circuit split, but the decision in Ritchie v. Tyson goes against the weight of decisions from the 4th Circuit, the 8th Circuit, the 11th Circuit, and 2 district court opinions in the 11th Circuit.
You just, wait, the 11th Circuit, you said you hadn't spoken, but the Ritchie goes against the 11th Circuit.
Sorry, I
Okay.
misspoke.
All right.
The 4th, the 8th, and the 10th, and 2 district court opinions that are from courts in the 11th Circuit. The other point I want to make just briefly on statute of limitations, I understand that the commission did overrule Judge Walker's decision in Oxendine. That said, Oxendine did appeal the commission's decision to the Superior Court. I understand the Superior Court never addressed his arguments because the commission settled in that matter. So I do think the statute of limitations argument is still live, and that Judge Walker's opinion has some authority. With respect to the factual allegations, I will just reiterate briefly the argument I made earlier, which is that the definition of campaign committee, independent committee, contribution, and expenditure all are terms of art that require a purpose, a specific purpose, right? A contribution has to be made for the purpose of influencing an election. An expenditure has to be made for the purpose of influencing an election. And the complaint does not provide facts with respect to a significant number of the transactions that are in it to make that purpose allegation.
But doesn't it just take one expenditure? It doesn't take, again, we're not doing, like Commissioner Hicks said, is it 10%, is it 20%? In the state of Georgia, it's one expenditure to directly advocate for someone running for office, to be an independent expenditure committee. Would you agree with that?
I would agree with that, assuming that the definition of expenditure
Says vote for, and then
Correct.
a list of candidates.
But
and
the
then
amended-
You're paid for by was at the bottom. Can you just dumb it down for me to tell me why that is not an independent expenditure and why you guys would not have to register and report?
Well, it's absolutely the vendor argument, which I want to go into on. But I want to be clear, the amended complaint in this matter alleges that there were $3 million and $4 million of contributions and expenditures. It doesn't allege that only, for example, the door hangers associated with the best print and design invoices constituted expenditures. It alleges that our operating expenses for health insurance were expenditures. It alleges that all types of transactions were contributions and expenditures without any tie to an election, aside from the fact that they were made during an election year.
Can you go back to that one that we saw that said vote for Stacey Abrams and all the other people, and had your paid for by on it? And if you're going to say the vendor argument, but then it wasn't paid for by you, it would have been paid for by the vendor, whoever the vendor was, and if not, then it was concealing the true identity of the person paying for it.
Right, but there's no allegation, of course, in the complaint that there was a misused disclaimer or an improper disclaimer. So I don't think that is an issue today.
Would be of issue if we agreed with you saying that it's a vendor argument. You would have to say it was the wrong disclaimer then.
Correct. So we have you've heard this argument before, right? Because we made this argument in 2019. There are facts and contracts and agreements, and you have text messages and emails, other materials that bear out the fact that New Georgia Project Action Fund was acting as a vendor on behalf of PowerPack Georgia in 2018, and with respect to the runoff that was in late 2018. There were 3 contracts that were entered into pursuant to this agreement. Dated October 8th, 2018, the 14th of May, 2018 for the primary, and then there was a contract related to the runoff. It appears that the commission is still pursuing these allegations, although there really is no basis for doing so. So we put together an illustration that shows how the vendor argument works. Because really what happened here is that the bank records that the commission staff received corroborate the fact that New Georgia Project Action Fund was acting as a vendor on behalf of PowerPack Georgia. There's nothing that we're hiding here. We've produced the 3 contracts, and they're exhibits to our motion to dismiss. You see the contracts were dated, the dates that are here on the slide, May 14th, and then paid on May 23rd, October 8th, which was paid on October 11th, November 27th, which was paid the next day on November 28th. Where did the money go? It went to pay individual canvassers, field offices, paid for canvassing materials, and for transportation. So when you see the long list of transactions in the amended complaint, you see this exactly playing out. You see that on May 14th, you see that on May 23rd, New Georgia Project Action Fund received money from PowerPack Georgia. The same day and the very next day, you see a long list of individual canvassers who were paid pursuant to that contract. There's been no evidence presented, no materials presented that those individuals were not paid pursuant to those contracts. And so you see payments made to real estate offices. You see payments made to Enterprise for vans to transport canvassers.
Excuse me, Ms. Branch, Commissioner Watts.
Were any of those canvassers hanging those door things that said vote for any of the 7 candidates?
So that's the point, is that the amended complaint doesn't allege which materials anyone was carrying. There's nothing that ties the payments being made to the materials that are being carried. And so, yes, it's not true, as Mr. Cusack said earlier, that the PowerPack disclaimer was not used on any of the materials. That's just plainly false. In one of the exhibits to the amended complaint, there is a script, and we've put the slide up here that says this effort has been paid for by PowerPack. That was on the script that the canvassers were carrying. It is simply not true, as the declaration stated that was put up, that all of the PowerPack materials were discarded or put to the side. That didn't happen. Yes, certainly the canvassers wore New Georgia Project Action Fund t-shirts. They correctly identified themselves as being representatives of New Georgia Project Action Fund because they were vendors, they were hired, but they also did use the paid for by PowerPack disclaimer. Were there times when the disclaimers may have gotten mixed up such that they used the paid for by New Georgia Project Action Fund disclaimer and it should have been a PowerPack disclaimer? Potentially. But again, the amended complaint doesn't tie any of the expenditures or transactions related to canvassers to whatever materials they were carrying. It is certainly true that canvassers carried nonpartisan GOTV and voter registration materials. There's nothing in the amended complaint that indicates that Joe Blow canvasser wasn't carrying such nonpartisan materials. There certainly is.
You can do both.
You could do both, but the amended complaint doesn't address one way or the other. What is clear from the amended complaint, though, is that New Georgia Project Action Fund was acting as a vendor. And there was a question earlier about PowerPack. So PowerPack was registered as an independent committee in 2018. It reported its payments to New Georgia Project Action Fund. And you see here it says, get out the vote canvassing for Stacey Abrams. That's none of this activity was taking place under cover of darkness. It was publicly reported. There's no obligation for this to be reported twice. PowerPack similarly disclosed its contributors. So the individuals who contributed to PowerPack for this effort were disclosed on their reports. There's no hiding of money here. In the motion to quash hearing, Mr. Amati, I believe, stated that the fact that there was evidence of canvassing that did not involve Ms. Abrams and that took place outside of Metro Atlanta meant that New Georgia Project Action Fund was not canvassing pursuant to the PowerPack agreements. That's simply false. The agreements, there were 3 separate agreements, and they each covered different candidates in different geographies. You see here we've highlighted the relevant piece of one of the agreements, which discusses canvassing in the Black Belt. So that's certainly outside of the Metro Atlanta area. That's what they were doing. You see in the second excerpt, there was canvassing. They were hired to do canvassing in Augusta and Columbus and Macon and Savannah and Albany and Valdosta. And you see there, they were hired to do canvassing to support Barrow for Secretary for State. So it was not just focused on Ms. Abrams. It was not just focused on the Metro Atlanta area. They engaged in a significant amount of canvassing on behalf of PowerPack throughout 2018. And a number of the transactions that are listed in the amended complaint relate to that very activity. They were paid nearly $700,000 for this activity. And so that activity should be excluded from this matter. As a legal matter, a vendor, like the Action Fund, receives payments, not donations, and they engage in activity for the purpose of fulfilling their contractual obligations, not for the purpose of influencing an election. That's why payments to vendors are not reportable. They're not treated as contributions. They are reportable expenditures. The reporting impetus falls on the payor, in this case PowerPack, not on the vendor. Canvassing vendors are not required to register and report with the commission. And the fact that the amended complaint relies so heavily on activity that New Georgia Project Action Fund engaged in pursuant to these contracts really provides a reason for the commission to not find a reasonable basis to proceed with this investigation.
Well, explain that vendor part to me. If PowerPack is paying the Action Fund, okay, to be their vendor, to do independent expenditures, right, for Stacey Abrams. That's what you showed us. That specifically said that, okay? How then, and you said that independent expenditures wouldn't have to be reported by PowerPack because it paid the Action Fund as a vendor. So who reports the independent expenditures if it's not the vendor who's putting their paid for by on it? So how's that work?
PowerPack did report the expenditures made to New Georgia Project Action Fund.
The lump sum, but not the and you just said that the Action Fund actually did canvassing, they did get out the vote, they did all these other things that aren't independent expenditures. Who is responsible to show the independent expenditures reported separately? If you're saying PowerPack, then are we saying PowerPack has to show what they paid the Action Fund for your get out the vote, and then they have to show each almost like end recipient? Is that where your argument's going? Because I don't understand who's responsible for paying if it wasn't the person who has paid for by the body.
Right, so your question is really who is responsible for reporting the payments to the sub-vendors, to the people who were paid pursuant to the contract, and like the canvassers, the field offices, so the printers. So Georgia law doesn't cover that. Sub-vendors are not required to be reported. There was a payment made to Georgia.
I'm going to disagree there unless somebody else can tell me I'm wrong. The Georgia law requires all independent expenditures to be required. It does not separate it out, vendors, sub-vendors, or anything else. So I guess that's where I'm getting confused at. Otherwise, what we're saying here is, as long as we play a shell game like this, then nobody ever has to actually report which expenses are going to who. All it's saying right here on the Power Pack is that they did it for Stacey Abrams. We have seen on the printing that is paid for by the Action Fund, multiple people were identified to be voted for it. Okay, multiple people. So the independent expenditures aren't being reported. I don't know.
Well, I can say for certain that New Georgia Project Action Fund as a vendor was not required to report this activity. Vendors who are paid to perform services are not required to register and report as committees. That's true under Georgia law, that's true under federal law, that's true under every state campaign finance law that I'm aware of.
I think you would have a better argument if it said everybody else's name on this except just Stacey Abrams.
So I mean, this may be a shorthand of reporting by Power Pack.
You think we should add them?
Well, they could certainly amend their report to include additional candidates if that's what their records show. But we're here today to discuss New Georgia Project and New Georgia Project Action Fund's liability, and they were not responsible for reporting this activity. It was publicly disclosed on Power Pack's reports, and I mean, it's very clear what the activity was for and who it was in support of. If there were additional candidates who should have been included, then
it seems like a shell game again. I don't understand. It has the action funds paid for by at the bottom, identifying all these other people. That's where my confusion is. I feel like we're on a merry-go-round. You know? I don't understand that. You're saying maybe it was an accident that the paid for by was wrong, and maybe it was an accident that Power Pack should identify more people.
the point is we don't know, but I think as it was raised earlier, the materials that you saw that Mr. Cusack put up earlier, they haven't been tied to any specific transaction in the amended complaint in any event. And that's true for all of the exhibits, most of which didn't actually cost any money because they're Twitter posts. But
Hicks has been waiting for quite a while. The Commissioner, let's go ahead.
And you may, Ms. Branch, maybe get into this point, but I'd like to know your opinion on the affidavit by Stacey Hopkins, who says that she witnessed material being, from PowerPoint, canvassing being thrown in the trash, and that New Georgia project material was replacing it. Which I'm assuming, well, this is on the oath, so I'm curious about that.
I don't know the specifics of that. I know that Ms. Hopkins was an employee of New Georgia Project, I think for 4 months and, during the 2018 election. I don't believe that she would be, and this is related to her performance as an employee. I don't think that, I think there was a separation, and I don't think that she would be rehired. I don't think she's eligible for rehire. But beyond that, my understanding, and you can see here, is that the Power Pack materials were not thrown in the trash. There is an exhibit to the amended complaint that contains the disclaimer, this effort has been paid for by Power Pack. Right. Those materials were used.
Right, and I don't think this is saying that all of the material is thrown in the trash, but that she witnessed this material being thrown in the trash. So you're suggesting that her statement here is incorrect?
I can't, I can't opine on the validity of her statement without discussing it with her. Based on what I know from my clients, Power Pack materials were not thrown in the trash. And they were in fact used throughout the state of Georgia to engage in canvassing. New Georgia Project Action Fund complied with the terms of the vendor agreements that they signed, and many of the transactions that are in the amended complaint are related to that activity. I do want to point out one exhibit that is in the amended complaint that was discussed earlier. And this is a picture of canvassers who say they're kicking off canvassing at our new office in Norcross. This tweet is dated October 9th, 2018. This follows the date of an agreement that New Georgia Project signed with PowerPack. So they entered into the agreement on October 8th. On the next day, on October 9th, you see this. These canvassers were engaging in canvassing activity pursuant to the PowerPack agreement, and you see that all through the bank records. So you see a timeline here with respect to each of the agreements. There's the October 8th agreement. You see a payment in the bank records being made by PowerPack to New Georgia Project Action Fund on October 11th, and then after that, you see names of individual canvassers who are being paid to canvass pursuant to those agreements. Same thing with respect to the runoff agreements. So it's our position that the bank records that have been obtained by the commission and that are in the amended complaint actually corroborate the vendor relationship, and that vendors are not required by law to register and report as independent or campaign committees. There was discussion about, it wasn't clearly articulated, but I do want to address it, sort of paying of canvassers out of the New Georgia Project bank account, even though these contracts were signed between PowerPack and New Georgia Project Action Fund. And there's a simple explanation for that. And that is that New Georgia Project Action Fund was the entity that had payroll at that time. And so canvassers were paid out of the New Georgia Project account. The New Georgia Project Action Fund reimbursed, New Georgia Project for those payments. And that happens between affiliated nonprofits all the time. I'd like to refer you back to the Boulder Advocacy fact sheet that I gave earlier, which talks about 501c3s and C4s sharing employees. That is exactly what happened here. You can have payroll out of one of the affiliated organizations so long as the other one reimburses for time spent by employees working on the other organization's activity. That is what happened here. It is common amongst affiliated nonprofits. It is sanctioned explicitly, sanctioned by the IRS rules, by the Common Paymaster rules. There's nothing that is problematic about those reimbursements having taken place. It's really for administrative convenience when you're running affiliated nonprofits in this way. Final point I'll make is just that the amended complaint is deficient because it does not tie the spending out of the bank account with specific payments. It doesn't show that any of the payments that were received, that were donations, were made for the purpose of influencing an election. It doesn't show that any of the payments that went out of the bank account were made for the purpose of influencing an election. And so we do not think that there's a reasonable basis to find that a violation has occurred for that reason. Thank you.
Thank you, Ms. Branch. Good question.
Yeah.
Before you.
Sorry, so are you arguing that the complaint needs to have a one-to-one tie that, like, is absolute proof that this money went to go pay for this canvasser to hang those door things that Commissioner Thompson was talking about? Or I mean, you can make the allegation without having necessarily proof in hand.
Sure. And I don't think that, a full suite of evidence is required at this stage, but when you're alleging that two organizations have spent $3 million or received $3 million and spent $4 million to influence an election, and you can't point to one transaction that's tied to materials that were created for the purpose of influencing an election, I don't think that's a reasonable basis to proceed with the investigation. I don't think that the amended complaint provides facts to support the allegations that it makes. And yes, there is this picture of the slate card, but there's no tie. There's no tie between the transactions and the amended complaint and the payment for the slate card. There's not a single factual allegation in the complaint that shows that. And so I think that if you're going to allege, this kind of spending, you need to come with some kind of facts to support the allegations. And that's what the legal standard, reasonable basis, requires. So I don't think that you need to have, a one-to-one showing at this point, but you need to have at least something. And I don't think that the staff has provided that.
Again, before you take a seat, because I'm going to ask you and Mr. Cusack this question, and maybe Mr. Amati, if you wanted to provide a benefit of his information on this one as well. But, one of the specific allegations that we talked about much earlier this morning was that the project and the fund, that it failed to disclose approximately, we talked about $4.2 million in contributions in 2017 and 2018. If the commission was not comfortable with actually finding that there are reasonable grounds to believe a specific amount, would there be anything to prohibit the commission today from saying that, that the two committees failed to disclose an undetermined amount in contributions in violation, that there's reasonable grounds to believe that the groups failed to disclose an undetermined amount in contributions in 2017 and 2018? Is that something, is that permissible, or are we somehow bound, since it was alleged in this fashion, to stick with that? You want to, since you're up there, I'll be more than happy to listen to you first.
Sure.
Do you understand what I was asking?
Yes, and maybe the staff should speak on that since it's their burden.
Okay.
But
That's fine. All right.
I don't think, Mr. Chairman, there's anything that can preclude the board from considering that. But at the same time, I think under Georgia law, it's clear if you're in for a penny, you're in for a pound. If an organization is an independent committee, it has to disclose all of the money going in and out of that organization during the election period. You don't get to pick and choose which are earmarked for and which you decide aren't. You're an independent committee under Georgia law, you're not. And so the numerical, the numbers we listed were the amounts that came in and out during the election period where we believe they should have been a registered and reporting independent committee.
Let me ask this question. This is perhaps as close an analogy as I can come up with. When you read the definition of independent committee, a labor union could be an independent committee. So say a labor union decides we want to campaign for so-and-so for labor commissioner. That's important to us. So we're going to tell our members to go out, we're going to walk. Now, the labor union is doing a lot of other things, negotiating contracts, training, things that labor unions do that aren't necessarily political, but they could still be a independent committee for purposes of the campaign, and we'd have to figure out what they have to disclose.
Yes and no, Commissioner. If they were operating out of one account,
Okay.
then that account would have to disclose everything. Now, in practice, a labor union would have multiple different entities, and the 527 would be bifurcated from the other groups. In this case, we're saying the C3 and C4 were effectively so intertwined that they're one and the same in how they were paying for activities for the other. And therefore, both of the organizations qualified as independent committees, and therefore, whatever came in and out during that time would have been disclosed.
And I think it's important that nobody's registered yet. So what entity would be registered?
Go ahead.
So I think it's important that there's been no registration yet, so there's no fictional sort of independent committee that's being created right now. So it would just be the C3 and C4 together in doing these. We see election political money going in and going out of both accounts. So subject to registration, disclosure, and filed reports.
Do you have any other questions or comments from anybody on the commission?
I do have one.
Sure.
For Ms. Branch, in my day job, I draft contracts for a living. I was all open, excuse me. I was very intrigued by your contract argument. I share some of Commissioner Thompson's concerns about the slippery slope, I think is where he was going. And I think that is an issue that's going to have to be vetted more thoroughly in a different forum. I was sort of noodling at a campaign fundraiser. Instead of handing out pledge cards, you just hand out subcontracts. And all the donors hire the campaign to go speak for them. Now maybe lawyers are smart. That may be a hole in our law. I think that's an issue that has to be, I think if we were to rule this on the contract issue today, we would be creating an issue that could be of some concern, and it needs to be addressed, and I think it needs to be addressed thoughtfully, but I don't think today is the day to do it. It does concern me, but I do echo Commissioner Thompson's concerns about it. My other concern on the contract is, and I know our jurisdiction is limited, when I think of a vendor, I'm thinking of a commercial corporation that's for profit. Here we have a contract with a nonprofit, and perhaps that's okay, perhaps that's not, perhaps that's none of our business. But that's another issue I think that would have to be vetted at a future time.
And if I can respond to that. So nonprofit corporations enter into contracts to provide goods and services all the time. And under IRS rules, nonprofits can receive sources of income so long as they are related to their exempt purpose. In this case, New Georgia Project Action Fund is an expert in canvassing. It has expertise in canvassing Black voters and underprivileged communities in Georgia, and it was hired for that purpose. If you think about, for example, a museum, when you go to a museum, it's a C3, but it has a gift shop. It's also allowed to rent out its space for weddings. So nonprofit corporations can receive sources of income. And New Georgia Project Action Fund was acting as a canvassing vendor, just as other vendors do, and they weren't required to register as a result of that. With respect to the argument regarding sub-vendors, under current Georgia law, and Georgia law as it was in 2018 and 19 when this activity was occurring, there wasn't a requirement for sub-vendors to register or for the payments made to sub-vendors to be reported. So I don't think it would be fair to tag New Georgia Project Action Fund for not reporting activity that wasn't required to be reported under the law. And with respect to the chairman's question about whether you could find reason to believe that a reasonable or an undetermined amount was raised or spent, I think that the requirement at this stage is that the complaint allege specific facts that support a reason to believe finding. And the fact that the complaint includes money transactions that clearly related to the Power Pack agreement indicates that it does not provide reason to believe that a violation occurred. That activity should be excluded. And if the commission wants to file a second amended complaint that excludes the Power Pack vendor transactions, then we should address that in a separate preliminary hearing. But I don't think that the amended complaint as it stands provides reasonable basis to believe with those Power Pack vendor agreement transactions included.
No, and I think that point was made clear by Mr. Amani, and also by the point that you make right there, which is that we have to remember at the stage that we're in, what the burden of proof is. We're not, the staff's not having to prove by a preponderance of the evidence at this point, that groups were in violation of the Campaign Finance Act, this way or that way. We're just here to establish whether reasonable grounds exist that the Campaign Finance Act was violated in one or more ways, so that the matter gets transferred to the Office of State Administrative Hearing. So again, I think it's important to know exactly what the standard is that we're looking for.
Any other questions or comments from any of the commissioners? Ms. Branch, you have anything else?
I don't, thank you.
Mr. Cusack?
Unless the commissioners have any questions for me, I'll stay and listen.
Okay. Well, I'll go ahead and start the motions. I'll initially move that New Georgia Project and New Georgia Project Action Fund, that we find reasonable grounds that they violated the Campaign Finance Act when they did not register with the commission as independent committees in 2017 and 2018 in violation of OCGA 21-534F1. Do I have a second?
Second.
Got a motion and a second. Do we have any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? That motion carries. In case y'all haven't figured it out, I'm going through the outline that I set forth this morning. So the next question I will call is that I will make the motion that the New Georgia Project and New Georgia Project Action Fund violated or that there are reasonable grounds that exist that they violated the Campaign Finance Act when they did not file disclosure reports with the commission that were required of them as independent committees 9 times in 2018 in violation of OCGA 21-534A1 and F1. A, 2 months prior to the 5/22/18 election. B, 1 month prior to the 5/22/18 election. C, 2 weeks prior to the 5/22/18 election. D, the 6/30/18 supplemental disclosure report. E, 2 months prior to the 11/6/18 election. F, 1 month prior to the 11/16/18 election. G, 2 weeks prior to the 11/6/18 election. H, 2 weeks prior to the 12/4/18 election. And I, the 12/31/18 supplemental disclosure report. Do I have a second?
Second.
Got a motion and a second. Do we have any discussion?
Just one point, Mr. Chairman,
Yes, sir.
if I may. Just clarify, because Ms. Branch did make this distinction at the beginning of the morning. The total dollar amount we alleged is not a specific violation, the $4 million and $3 million respectively. You're not proposing the commission change that number as alleged, which would apply to those dates you are motioning a violation occurred during. Because there was some discussion a moment ago about whether the commission could change that or not.
No, there's actually a separate allegation, as I understand it, because it cited a separate code section
Okay.
in the amended complaint that had the actual amounts in it.
Okay.
All right, we've got a motion and a second. Is there any further discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Mine was an aye, by the way, sorry. Motion carries. I'll make a motion that we find that there are reasonable grounds to believe that the Campaign Finance Act was violated when the New Georgia Project and New Georgia Project Fund, or Action Fund, geez, I'm sorry, I'm sitting here looking at too many pieces of paper, y'all, failed to disclose approximately $4,216,783.07 in contributions in 2017 and 2018 in violation of OCGA 21-5-34F2A. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, that motion carries. Make a motion that we find that reasonable grounds exist to find that the Campaign Finance Act was violated when the New Georgia Project and the New Georgia Project Action Fund failed to disclose approximately $3,200,449 in expenditures in 2017 and 2018 in violation of OCGA 21-5-34F2B. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, the motion carries. Going to move on to the ballot committee questions. I'll make a motion that we find that that there are reasonable grounds to exist that the Campaign Finance Act was violated when the New Georgia Project and the New Georgia Project Action Fund did not register with the Gwinnett County Election Superintendent as ballot committees in 2018 or 2019 in violation of OCGA section 21-5-34A2. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, motion carries. Make a motion that we find that reasonable grounds exist that the Campaign Finance Act was violated when the New Georgia Project and New Georgia Project Action Fund did not file campaign disclosure reports that were required of them as ballot committees 15 days prior to the election held on March 19, 2019, relating to the expansion of transit in violation of OCGA Section 21534A2B. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I will call the question. All in favor say aye. Aye. Any opposed? Hearing none, motion carries. I'll move that we find that there are reasonable grounds to believe that the Campaign Finance Act was violated when the New Georgia Project and New Georgia Project Action Fund failed to disclose approximately $646,422.89 in contributions in 2018 and 2019 in violation of OCGA Section 21534A2. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, motion carries. Finally, I will make a motion that reasonable grounds exist to believe that the Campaign Finance Act was violated when the New Georgia Project, the New Georgia Project Finance Act, holy smokes. Sorry, y'all. That NGP and NGPFA, New Georgia Project Finance Act, what am I doing? Action Fund.
How many more of these you got?
That's the last one. I'm sorry, y'all. My notes are having problems here. New Georgia Project and New Georgia Project Action Fund failed to disclose approximately $173,643 in expenditures in 2019 in violation of OCGA Section 21534A2. Is there anybody that wants to second that motion?
I'll second.
All right. We got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Hearing none, motion carries. I believe that's all the questions that we have. Mr. Cusack, are there any other questions that you feel like we should have motions on with respect to the preliminary hearing?
I believe that's it from the commission staff.
Ms. Branch, any other questions you feel like were appropriate for the preliminary hearing that we did not address?
Not that I'm aware of.
We do appreciate yours and everyone else's time and work on the case. We do have to go to item 3 before we leave. Well, I'll go ahead and that'll be the conclusion of the preliminary hearing. I do have to go to item 3 on the agenda. I don't believe we had anyone sign up for public comment. Mr. Lane, there wasn't anyone that signed up over there, was there? Okay, is anyone here that wishes to speak on public comment? All right, hearing none, I'll make a motion that we adjourn the meeting. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Thank you all very much.